Good morning. Good morning. Good morning. It's Thursday. It's September 14th. We're now like mid-September. We're in the iPhone part of September. we're like we're iPhoning into the fall. It's like it's time for pumpkin spice and new phones. That's where we're at. It's good to see you, law nerds. I missed you all on Tuesday. It's going to be like that throughout the fall, which is why I have reminded you all to sign up at lawnerdalert.com. We have things coming. Some of the members already know, but we have things coming for you because the fall is unpredictable for me. There's a lot of travel in the fall. There's always a lot of travel in the fall. So it's wild. So the stream times get a little messed around with. Tuesday I ended up being off grid unexpectedly. So it's not because my internet went out. Judge Abby and I had like a girls trip planned and I was going to make some time to do other things, and then we had no internet, no cell, no Wi-Fi, and we just decided to choose a adventure and embrace it. It was not exactly what we were anticipating. We had a lovely time. So I am tired in a different way. Like fall is just busy. I knew fall was going to be busy. Fall is just busy, but we had a really nice time. So with all of that, today we are going to cover all of the things going on in Idaho. I saw this question. I'm sure we're going to get this more. Are we going to talk Murdaugh? Not today. I'm going to wait till the end of Murdaugh's hearing. That is still the last time I peeked in. That was still live. I will cover today's Murdaugh scheduling hearing later on in the week. Steffi B in the chat asked if I heard Tom Girardi told the prosecutors, fuck you, after they played his voicemail. I did hear about that. We're going to talk Girardi. Every time I do a Girardi video, you guys are like, eh. So we're going to move the Girardi stuff to quick bits because there are some of you that are very curious about following it, but it is a lower and lower percentage each time I cover Girardi. So the Girardi stuff will get a quick bits for a little bit. Here's what's going on with Girardi. With the competency hearings, there are still motions to be filed by the attorneys. So we still have another few months of waiting on a ruling because they're allowing the attorneys to file more motions. So there will be a motion from the state and then a motion from the defense. So I will go through those motions when it's time. But for now, there were hearings, there were things we're going there later. So we will touch on Girardi once we have those filings. It's going to be 30 plus days until we have those filings to go through the hearings. And then we're going to, let's see, today we're just covering Idaho. And then next week we will start topping into some streams that are multi-topic because there's a lot of stuff going on. Janelle, don't worry. I'm not going to stop covering Girardi. Don't worry, but we're going to cover it kind of in chunks when we have time to cover it. So for all of you that gifted memberships, thank you so much. It's very kind. Thank you, Victor Mann, for gifting memberships. Thank you, Elena, for gifting memberships. It's always so kind and appreciated. We have a members only live stream coming up next week. So next week, we're going to touch back in on all that. But because we've got hearings going on from yesterday in Idaho and motions that we haven't covered, we're going to cover all of that today. We will get into Murdaugh next week and we will go back there. So with all of it, that's what we're doing today. Just Idaho. So if you have questions about other stuff, the answer is going to be soon but later. Do I have thoughts about The Fugitive? I haven't seen that movie in a really long time. So it's been a minute. If you are talking about what was going on in Pennsylvania, I have not been following the news. I normally don't follow the news very closely at all. I have not been following the news very closely at all because I was offline. And my biggest concern about being offline was not losing my Pokemon Go streaks. I'm just being completely honest with you. I didn't want to lose my Pokemon Go streak. So it was like, I need at least a little bit a little bit of cell phone so I can just like catch a Pokemon and like spin one stop like daily. I can't lose my daily streaks. And it's funny because Judge Abby didn't want to lose her Duolingo streak. So we were like, we have to find like just we have to find a little cell phone coverage so we don't lose our streaks. Because today was my 7-day streak at Pokemon Go and there's still a bonus XP and I need it because I'm trying to level up and I need millions more XP at this point to level up. So that's where I was at. But what did I think? I didn't follow it very closely. I saw that it happened. It seemed that they evaded law enforcement for quite a while, and then everybody else was like, "That person's over there," and then they were caught. So generally, people get caught. So I'm trying to level up to level 43. Generally, people get caught. So yeah. What else? So we ended up accidentally off grid. So all the things going on in the news. Nope. Since let's see, I don't know what day is it. It's been like a full 2 weeks. So today's the 14th. I was traveling for a family wedding in New Jersey over Labor Day. So I left at the end of August. We traveled for a family wedding. My kids hated that we were traveling. We were staying in an Airbnb multi-generationally with my parents, my husband and I, and my children. My children were not loving it. My parents then got sick while we were in New Jersey and could not travel. So my travel plans got changed to help take care of my parents. Then I got sick after taking care of my parents. And so since like I left for New Jersey to now, I don't know what's happened. I don't know what's happening. Nope. I'll catch up. I just haven't caught up yet. And the thing is, I don't mind being off grid. I like being off grid. I don't mind like going on a cruise, not paying for the Wi-Fi, turning off my phone. I didn't know that we were going to be off grid. Judge Abby did not know. Like we were not prepared. We were not prepared. So when we got to where we were staying and they're like, we don't have any cell service or Wi-Fi, we went and looked at each other and went, What? 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 What do you mean? What do you mean? What do you mean? We're not prepared for that type of a trip. So we, in the dark, drove back down the mountain to find cell service to tell our significant others and for me to tell Team Baker and everybody else that we were not going to have any service. It's the kind of thing I need to know. And we did not know. It was not made obvious to us. We did not know. So that was unexpected. Maybe we should have expected it. We were both too tired to expect it. We were like, mountains. Anyway, we had a very nice time. It was a lot of fun. The Smoky Mountains are beautiful. So we spent some Smoky Mountain time and it was lovely. It was really beautiful. I got to go see things I hadn't seen before. I feel like more of a Tennessean. Judge Abby grew up in Tennessee. So it was really fun getting to do kind of, and Judge Abby now lives where I grew up. So she's gotten to do all of the like, oh, we used to go here in high school. Oh, we used to do that. Oh, we used to do that. From me, she's got like the tour of my childhood and like high school and how I grew up. So we got to do a little bit of that where she used to vacation, things her family loved. So it was a really good friend trip. We had a nice time. I did not live stream on Tuesday, but we found lots of live streams. So I saw a comment in my post where I said, I'm not streaming today. Here's where I'm at. I am in a stream. And I love that somebody commented, you might not be live streaming, but you have found a live stream. We found lots of live streams and waterfalls and the mountains. And I love the mountains. I just had not been prepared for hey, there's going to be large chunks of time where I am completely disconnected. And once we made a accommodation for like letting people know when we would be unavailable, it was great. So that was fun. So today we're just doing Idaho stuff. I am still like tired. I'm still tired. I got back like to my house to sit down late last night. And so it's been go, go, go. We've been like, I've been go, go, go for weeks. And I've got a few weeks at home, and then I've got another conference that I'm going to. So here we are. I feel somewhat mountain refreshed, sort of. I hope y'all liked the podcast yesterday. It's a hard topic to cover. I think that one's going to stick to podcasting for me. It's a little easier. When I get, when topics are really difficult, A, I tend to repeat myself more. B, I tend to take longer pauses. And C, there's times when I want to rethink things and rephrase and cover it a different way. And I need more pondering time when topics are really sensitive and difficult. And so when it comes to 8 passenger stuff, I'm going to be covering that mostly on podcast and breaking down the law side on podcast, but I'm not covering it like Kohberger. Kohberger, we've covered like every single twist and turn in this case. I am not going to cover every single twist and turn of that case the same way. I will kind of overview the legal stuff as substantial legal stuff happens. And so it will be not in-depth coverage like this. I can't live there. And I think a lot of you can't live there either. Like, Utah's beautiful, but I cannot live in Utah in that case. It is too much. It is not a headspace anyone wants to be in all of the time. It's too much. So we're going to keep covering every twist and turn in some of the cases we're covering. We will get to Murdaugh next week. But with 8 passengers, it's, again, overview of the legal stuff. We've got to get back into Corey Richins. We've got so much stuff to do. Today, though, we should get started because here's what we're doing today. Replay crew, love you. We are going to do the motions that lead up to the hearing and covering what the prosecution is saying about cameras in the courtroom, what the defense is saying, and what the media is saying. And then we're going to go to the hearing. Cameras in the courtroom is something I feel strongly about. It's also something I'm personally invested in because I love covering live court with y'all. If we have to cover it on delay, we will. If we have to cover it by audio, we will. If I have to get my ass on a physical plane and go, last resort, but I will. I will go. I would prefer to sit in my comfy blue chair here. But if I have to go sit in court, I'll go sit in court. Sure. Rather stay here. So that's what we're doing today. Motions, court hearing. And then we will get to Murdaugh next week. Yes, there's lots going on in Murdaugh court today. Yes, court is live today. We're going to do that later. There's lots going on with Dick and Jim and blah, blah, blah. But today we're doing Idaho. All right. Ready? Are we ready? We should get going. Let's roll. Law Nerds, it's good to see you. I've missed you. Thank you all for being so kind. Your comments are so incredible. When I posted I would be unexpectedly unavailable, y'all were like, that's great, girl. We'll see you when you get back. I appreciate you. You guys are the best. You guys are the best. All right, let's go. Welcome to The Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. Who was like, hey, Emily, isn't that the podcast intro? Anyone? Anyone? Maybe you? Maybe me? I don't know. But it is. Let's go again. Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it. All right, y'all. Now that I've got the right intro going, we have to take a moment. We are professionals here, but we have to take a moment to actually be professionals and thank our sponsor for today's show before we get all the way into it. So let us do that. Can I tell you how much I love a sponsor that's like, girl, just do it live while you're live streaming? Thank you to Gerard Cosmetics for sponsoring today's stream. You guys know I talk about Gerard Cosmetics and have for years, and we have our amazing Law Nerd collab. This is the one on my desk. Yes, it's almost empty. Why? Because I use it all the time. It is the only lip gloss I can reliably stream with because it doesn't get sticky and gunky and goopy and gross. And right now, from September 14th to the 17th, the entire Gerard Cosmetics site is buy one, get one free. That includes the bundle and the box set for all the Law Nerd goodies. You can see the box set right up there. There are a few boxes left on the box set. We ordered some more because y'all loved them. So there are some more boxes left. And then you can get your bundle if you want to just get the 3 and not get the box. You can just get the 3 different colors from Gerard Cosmetics. You too can have hearsay, facts, and objection. It's fantastic. I love them. They are so cute. So if you have not yet purchased your EDB goodies or anything that you love from Gerard Cosmetics, they are buy one, get one free. So you could purchase something like Hair AF and get a different item. If you want, you could get the box set and then get a different item. You can add any of your stuff together. The Hair AF is fantastic. If you look at Dustin Daly, and I know a lot of you follow Dustin. If you look at Dustin, you will see all of the Hair AF before and afters that he talks about, and you will see them from him and in his own experience. So Dustin has had an incredible experience with Hair AF, and as have others. So if you go and look at the Gerard Cosmetics site, you will see all of that. The clean canvas is fantastic. It's a eyeshadow base. And then the Slay All Day setting spray in 13 different scents. I love them. I use mint chocolate chip and rose quite a lot. So if you are ready, go head over to Gerard Cosmetics. We have all of our links in the description and through the chat. Free US shipping for orders over $50, international over $150. So go shop. Go shop. Will there be new colors in the future? Jess, we're talking about new colors. We're talking about new colors. We're talking about it. So we'll let you know. For now, you've got the 3. And they are very, very, very wearable. So with all of it, we need to go to Idaho. Are you guys ready to go to Idaho? Get on the plane. That's where we're going today. Today, we are spending the day in Idaho. It's lovely this time of year. Look, in Tennessee, the leaves are starting to change and fall. Like it is, this week is fall. Like it was like, hello, we're fall now. That's great. The air is starting to get crisp and cool at night. It's lovely. So I imagine it's also getting lovely in Idaho. So let's go. Idaho for the day. If you have been following the Kohberger case, you kind of know that the back and forth has not stopped. The trial date got pushed, and now there's lots of time for all of the legal wrangling, like literally all of it. And Idaho in court is fighting over the media. I covered the defense's motion to keep cameras out of the courtroom. Time is a construct, so whenever ago, I'll put it down. The mods will find it, and we will put it down below in the description when I last covered that. We're going to take a look at that motion real quick. I've already done a deep dive. We're going to overview it. So we're going to overview what the defense is asking for. Then we're going to go to what the prosecution said. Then we're going to go to what the media is saying. Then we're going to go to court. I'm going to also flip to the last page first. The judge hasn't ruled on this yet. So we're going to evaluate all the arguments, and keeping an eye on cameras in the courtroom is something I will do in every case we cover, because I think there are ways to do it. And I think there are ways to do it well. And I think we saw a lot of that in the Paltrow case. There were very strict rules in the Gwyneth Paltrow case, and I really think that they worked pretty well. So let's take a look first at Emily. Is your screen shared? No. Should it be? Yes. Let's take a look first at the defense's motion, just because their pictures made me giggle. And that's why we're going to look at their motion first. So let's see. I want cameras in the courtroom too. Amy said the judge hasn't ruled on much in this case. There's been a lot of things that have gotten put over. Aaron said EDP Airlines sometimes ends up in the wrong city. This is why I don't run an airline, or book my own travel at this point. So there's that. Where is my screen sharing? Screen share, Emily. Let's get the screen sharing going. There we go. Yay, screen sharing. It's like riding a bike, y'all. We're back to streaming. Will it be a long stream today? Because I am just gonna take time. Yes. Yes. Am I moving slow? Yes. Is my brain moving slow? Yes. Yes. All right. Motion to remove cameras from courtroom. This is Kohberger's motion. And they're like, Your Honor. They keep showing his face. They keep zooming in on his face. We don't want them to zoom in on his face. They need to just focus on what's happening in court. They say press observers have thus far failed to comply with the court's direction as the continued publication of images such as those shown below continues to present day. They are saying that the court warned. The court did not make a court order. The court can make a court order. The court warned press observers not to focus strictly on Kohberger and to show a wide shot of the courtroom if they wish to continue filming court proceedings live. There is a still pool photographer and a video pool photographer. It's so funny because some of those who scooted by just to complain about my coverage of Johnny Depp and Amber Heard were just like, Emily, you covered this whole trial and that's under fair use. People still don't understand how pool camera works because fair use in copyright is different. Pool cameras mean one person is given access to the camera. No one owns the copyright in it, and it is news. And the pool camera is obligated to distribute it to any other outlet that wishes to cover it. It's not fair use. There's no copyright in that. Anyway, people get confused when they try to. They try, and then they show their ignorance when they try. It's kind of hilarious. So pool cameras is one camera, and they have to distribute the feed to any media outlet who needs it. These are still camera shots. There is also a pool still photographer. Same. They have to distribute it to anyone who wishes to publish it, and they can't charge for it. They don't own the copyright in it the way that you could do it in other scenarios. Like if a paparazzi outlet takes a picture of a particular celebrity and that celebrity uses it, then the paparazzi, you have seen time and time again, certain outlets turning around and then suing the celebrity for using the picture of themselves, saying, no, we own that photo. And we've seen this come up time and time again. The photographer owns the photo. Not the case with pool cameras, unless there are specific rules. But anyway, they say the photos are a blatant violation of the court's directive to cease focusing exclusively on Kohberger. It doesn't mean they can't focus on him. Like when he is coming into the courtroom, he is the center of what's happening in court, right? Further, the cameras continue to exclusively focus on Kohberger, provides fodder for observers and purported analysts. I know they're not talking about us. Purported analysts on social media who are not bound by notions of journalistic integrity. Someone point to me who's bound by notions of journalistic integrity. I can't name any outlets anymore. I can name journalists that have shown that they have integrity. I can't read all the rest of it. So, purported analysts on social media are not bound by notions of journalistic integrity who have potentially an even greater reach than traditional media outlets. You're mad. Well, the defense isn't mad. The defense just wants cameras out of the courtroom. The media gets mad because a lot on social media have a larger reach than traditional media outlets. The proliferation of these images and videos is plainly observable on social media platforms. Well, the court can't go observe them. But what's funny is they post things that they're like, the reach is plainly observable. This has 6 retweets and 1 quote tweet or quote X or whatever it's called. And so they keep going through and talking about the Daybell case. They talk about somebody who had 9 comments and 5,000 impressions said that his zipper might have been unzipped. Good God. Okay. So this is the defense's motion that we've already gone over at length. They're like, look, you might be able to see what's on defense counsel's table. Defense is looking at the Zoom call, or defense is, looking at the table. This one's from Long Crime. That one's from News 7. Again, they all come from pool cameras. Conclusion: the press have failed to obey the court's directive not to exclusively photograph and record Kohberger to the exclusion of all else, jeopardizing his ability to undergo fair judicial proceedings, free of undue prejudice and juror bias. As such, cameras must be expelled from the courtroom for the duration of Kohberger's case, including pretrial hearings as well as the trial itself. This is what the defense wants. The defense wants all cameras excluded from the courtroom for the entirety of the rest of the case. Let's see what the prosecution had to say about that, because the prosecution responded, I've not covered this yet. So this is the state's response. Let me shift my tabs around so we don't get too tabby. This is the wrong one. There it is. We have lots of documents to go through the day. All right, the state's response. The state also doesn't give a shit about cameras in the courtroom. This is the state as the court and the parties, including interveners. Interveners are the media group. So we saw the attorney. Oh, hold on. Where's my? Nope, wrong one. Sometimes it's better when it's the wrong one. Attorney Olson, Kathy Olson, is the attorney for the media coalition that are the interveners. It's the same media group that intervened for the non-dissemination order, group of media outlets. This is the same attorney representing Professor Schofield in the defamation case. So if the name looks familiar with you, same attorney. Attorney Olson, who represents the media coalition. They are the interveners. So as I talk about interveners, I will use synonymously media interveners because they are the same. As the court and the parties, including interveners, are aware, this case has and continues to attract significant public and media attention involving not only traditional media, but also a broad range of social media related posting, blogs, podcasting, and other disseminations. It's so funny how they always forget about streaming. Leave us alone. Don't talk about it. It's probably the biggest way people watch trials is streaming, but that's okay. Shh. Blogs. Let's talk about blogs. Counsel. Streaming. YouTubing. I don't know how many blogs there are. I imagine they're limited. This case also involves significant physical and emotional components, not only by virtue of the nature of the killings themselves, but also by the myriad of circumstances surrounding the victims, their associates, friends, family, and the residents at 1122 King Road, and so forth. We don't know anything about the circumstances. We know nothing about the circumstances. There's a lot of speculation about the circumstances, but what is known, what is actually known, is very little. It's interesting that they say that. This case will necessarily involve not only evidence of a graphic nature, every murder case ever. You streamed the Shabusiness, the Shabusiness case streamed. Audiences will choose if they can handle testimony of a graphic nature. This case will necessarily involve not only evidence of a graphic nature, yes, but also testimony from a number of young and vulnerable witnesses, yes. These include the surviving roommates of the victims in this case, and also a number of the University of Idaho co-eds and family and friends. In addition to, well, we know who's going to testify at trial, but we kind of knew that already. In addition to, and at least partly as a result of the substantial traditional and social media coverage, certain witnesses have already been subjected to threats and harassment, including physical intrusions directed not only at the witnesses, but other university co-eds, but their extended family and friends. Here is the problem. This is continuing to be a problem. And this, I don't know how to, I know what we can talk about with cameras in the courtroom. We can talk about rulings like they had in the Paltrow case, where it's like it has to be focused on the speaker or a wide view. That's it. You can't just focus in on the defendant's face reacting to what they're hearing, blah, blah, blah. How to limit this? It's amplified by social media, but it's not because of social media, right? This is any case that happens in a locality, people are going to know family and friends of victims and witnesses in that community. So social media amplifies what goes on in a given community, but those things would be known within a community anyway. This is not because of social media. This is amplified because of social media. This feels bigger because of social media, right? So those of you that went to high school before social media, things happened in high school. Kids were dicks. People got bullied. There were embarrassing moments. Those things still happened. Now they are amplified by social media, and it feels like the entire world can witness some of those things. And that was starting even when I was prosecuting in juvenile. It felt so much bigger because so many more people could see it. It wasn't isolated to just your one little community of people at your school or whatever. So this is amplified by social. I don't know how to fix this, because even if there weren't cameras in the courtroom, the news would still be reporting this, and this would still happen. Right? Seeing expert witnesses like driven off of social media because they testified in a case causes me a lot of concern. I have a lot of concern for witnesses. I have a lot of concern for surviving victims. It is concerning, but it can happen even with live tweeting from a courtroom, even with just having print journalism. It can still happen because you can't close the courtroom. You're still going to have people in the courtroom no matter what. You just have less of you have spin then, or potential spin then. There are some great journalists and reporters who just report, who just cover, sitting in court. This person said this, this person said this, this person said this, court said this. And then I noticed this, and that. But there are not a ton of those. The harassment of individuals on social media is a huge issue. But it's an issue in every news story, not just court cases. And that is an issue. I don't know how to solve that issue. I wish I knew how to solve that issue, but it's an issue with reporting either way. Because we're not going to a time before social media. We're here now. And even if this is just being covered on social media without video, there's still going to be audio. People's names are people still have to testify. Our Constitution is such that the defendant has a right to an open courtroom. The defendant has a right to see who testifies against them by name. You can't just hide witnesses, right? We don't witch trial, or we shouldn't witch trial. Social media being different. Our court system should not witch trial and does not witch trial, where you don't know who's accusing you, right? So for all of the good I think cameras do in the courtroom, social media still acts like social media, and that is still a problem. I don't know who harasses witnesses. What are you doing? People, stop it. It's not y'all. I'm just yelling into the void about this. Should have yelled at the river. The state fully understands the enormous value that responsible media has in helping the public to understand the true facts of what occurs in court. Excuse me, can you point me where the responsible media is? Can you just tell me which ones? It would sure make my life a lot easier. That responsible media has in helping the public to understand true facts of what occurs in court. You know what else helps people? You really want to know, counsel? Look, former prosecutor to prosecutor, do you want to know what really helps people understand what happens in court? When they can see it. When people can see the witnesses. When people can see how they testify. When they can see the arguments. When they can see what the lawyers are saying. When they can see if the lawyers made an objection or didn't make an objection. How did the court let this evidence in? No one objected. We can watch it. When people can see it. When people can see it happening. Then they understand the true facts of what happens. Because they're seeing it. Now, everybody might interpret those facts differently. But at least then you're basing it on your interpretation. on your view, not on your interpretation of someone else's view. Rob and Alita, good to see you both in the chat. But then how can the media convince people that they didn't just see what they saw? Right? Bryn in the chat said the phone throwing evidence. I never would have believed it. I never would have believed the phone throwing evidence. If the media had reported during the Murdaugh case that some law enforcement officer just like hucked his cell phone around his office, and then all of a sudden that was some kind of scientific experiment, I would have been like, we're missing a step here. Something is not being reported. What's wrong? That's how I would have felt about it. But we watched it happen and we all went, oh no. That's happening. How is that happening? What is happening? How is that even scientific evidence? I wouldn't have believed it. I would have been like, they must have misunderstood. We're missing something, right? Amy says, or the armpit body temperature. Yeah, I don't know if I would have believed that at all. I don't know if I would have believed that either. I don't know if I still don't believe that happened. And I watched it happen with you. We all saw the same thing. And I still question whether that was real. Because it was so fucking crazy. Yeah. C12EH said, and everyone will have their own perception of body language of a witness. And that's what jurors do, right? That's exactly what a jury does. They evaluate it together and then they talk about it. That's what we do on the internet, except we're not the jurors. We're just the observers. Kelly Garcia said, and the whole Darrell Brooks case. Yep, there's a lot I wouldn't have believed in the Darrell Brooks case either. Casey said the gun pointing. Nobody even really reported that. That was those of us watching the trial that went wild about that. Nobody really reported that Poot did that. The entire trial was a fever dream. Or the box fort. Yep, I don't even know if people reported about the Darrell Brooks's box fort. Good point. Remember Jason Momoa testified according to the print media. Rose, I do remember. I remember print media reported that Jason Momoa testified in the Depp v. Heard case because they misinterpreted other people's TikToks, which tells me that there were those in legacy media reporting, not like, oh, TikTok showed this, but watching TikToks to report and not just sitting there watching the trial. So the media was getting their sound bites from TikTok. It's fucking scary to me. Don't you have a giant monitor to just turn the trial on and have it on in the background? Let's continue. The state fully understands the enormous value of a responsible media. I'm sorry. The enormous value that responsible media has in helping the public understand the true facts of what occurs in court. The state believes, however, that those ends can be accomplished without the need for camera/video images or the physical presence of cameras in the courtroom. Thank you, ladies and gentlemen of the prosecution, for agreeing with the defense that we don't need cameras in the courtroom. If you can't hear my sarcasm, here's my sarcasm. Am I surprised that the government's like, hey, we're good without cameras? No. If I was a prosecutor on this case, would I probably argue the same thing? Maybe. Yeah, maybe. Depending on my witnesses. Maybe. If my witnesses were nervous, I might argue the same thing. Can't say that I wouldn't. I'm going to argue something different now. I'm in a very different position vis-a-vis where I was when they were my witnesses and when I was talking to the victims' families. I want cameras in the courtroom. I think this case is a case that needs cameras in the courtroom. I'm already seeing arguments over the DNA. There's complex issues here of DNA. I think at a minimum, that should be aired. I think there's room to air, maybe do audio only for the civilian witnesses and not their faces. And do all of the, government witnesses and the defense expert witnesses on TV, and just do audio only for civilians. There's room to deal with this. Absolutely room to deal with this. Based on the above, the state is concerned that allowing the presence of cameras in the courtroom will have a substantial chilling effect on the ability of witnesses to openly, fully, and candidly testify about some horrible occurrences. I don't know how it's different if there are people swarming the courthouse to fight for a seat to get in. Because it's all going to be reported on. Sometimes you might forget a camera's there, but you're going to look out and see a courtroom full of people. And I think seeing a courtroom full of faces is more stressful sometimes than seeing a camera. Even though the camera's going to broadcast to however many people, seeing a room full of faces feels more stressful than talking to a camera. Ask YouTubers who talk to cameras and then go talk to people in person. It's different. In addition, the state has the responsibility to take steps to ensure a fair trial for all involved. I agree with that. Judge Boyce's decision in Vallow Daybell, attached to the state's June 6th brief on video and photographic coverage, provides a thorough examination of the issues before the court. The prosecution is leaning into what the judge did in Vallow Daybell and asking this court to do the same. The state reiterates those same concerns, including the issues of jurors accessing the broadcast and seeing evidence which has not been put in front of them, and witnesses potentially viewing the broadcast testimony of prior witnesses. Those things can be handled with orders, I think. The state respectfully submits that the appropriate course of action would be for the court to prohibit cameras in the courtroom, both still and video, at a minimum during trial and during any other court proceeding at which victims such as described above might be called to testify. I mean, technically, I think they're witnesses and victim family members, but whatever. The state and the defense are in agreement. The state and defense are in agreement. It is not looking good for cameras in the courtroom. Let's go to the media's response to all of this, and then we're going to go to the hearing. And I really want to see the judge's body language at the hearing. I want to see what questions the judge asks the attorneys during the hearing, because that can often give us a little bit of an inclination as to what the court is thinking. And I would like to know very much what the court's thinking. But it's going to be difficult if you're the judge. It's going to be really difficult to look at the prosecution and the defense in agreement and do something different. Very difficult as the judge. All right. Let's go to the media interveners motion here. All right. Pull this up. My in-ears, I need a new wire. My in-ears, like one of them's dead, so I'm not getting all the sound I should be getting. So when we get to the court audio, you will probably be able to hear it better than I will. All right. Interveners' opposition to motion to remove cameras from courtroom. So this is the media again trying to intervene in court. Back up. What is the first thing we need to talk about? Oh, that's the wrong button. I was trying to get to my comments and then I almost got to the end stream button. I was like, no. Right. It's been a day, but it's not been that much of a day. The first thing we need is standing. So does the media even have a right to intervene here? The parties to this case are the prosecution and the defense. So does the media even have standing to come into court and complain about this? And does the court have to listen to them? I don't think the court has to listen to them. I don't think they necessarily have standing here. I'm interested to see if they address how they have standing and if the court asks them in their hearing if they have standing, but I don't know if they have standing to intervene. The media doesn't represent the people. The media represents itself. The prosecution represents the people of the state of Idaho. So let's get to this motion. My big question, standing. I might like what the media is arguing, but they don't necessarily have standing. So meaning they don't necessarily have a case in controversy. This is a great question. And I've seen a couple people in the chat ask about the Gonsalves family. This is a victim's family. What standing does the victim's family have to intervene? So the rights of victims in different jurisdictions are guaranteed by statutes and by bills. The rights of the defendant guaranteed by the Constitution. The rights of victims' families aren't always cut and dry. But what the court would say if the victim's family said we are unable to be in court, the court might agree to a closed Zoom, which is a very different issue, to allow those connected to the trial, victims' families, members of the community, to attend via a closed Zoom, but not be streamed. But they don't have standing to come into court and complain on their own. Even with their attorney still had to fight that question of how do you have standing over the non-dissemination order? And the attorney said, this is about me. I'm an attorney being hampered by this court's order. And the court's like, maybe, maybe not. So, viewer's voice, good to see you. The weather isn't the devil's taint here in Texas. It's getting nice and cool here in Tennessee. Nick, I was thinking about you. I wanted to call you this weekend, but I didn't have cell this week. What day is it? Thursday? I didn't have cell service because we ended up staying somewhere and we didn't know we wouldn't have cell service or Wi-Fi when we were in the mountains near Pigeon Forge. So I thought of you guys. All right. Let's continue on. This is the media trying to intervene. Interveners have faithfully followed the court's instructions at the June 27, 2023 hearing to not focus exclusively on Mr. Kohberger. During the audiovisual coverage of these proceedings, the examples provided by Mr. Kohberger in his motion are not representative of actual media coverage. Thus, the premise of his motion fails. Moreover, continuing to allow audiovisual coverage of the proceedings is the only way to ensure that the many community members affected by these crimes throughout the University of Idaho, Moscow, the state of Idaho, and the cities in which the victims' family members reside have an opportunity to see and hear the proceedings for themselves. That's not true, unfortunately. I would argue this too, but it's not true. Here's why. There are other ways to accommodate these members of the community and the victim's family. Now, in the Brooks case, the court is like, the only way to really ensure this, because there are so many, is to just stream it. Here, it's a bit different. The motion to remove cameras from the courtroom should be denied. Background: in June of this year, at the court's request, the parties and interveners, footnote 1, and this is all the media companies, submitted briefing regarding audiovisual coverage of these proceedings. Interveners urged the court to exercise its discretion under Idaho Court Administrative Rule 45 to authorize audio-visual coverage. Remember, this is the court's discretion, subject to carefully crafted rules designed to protect the state and Mr. Kohberger's constitutional interests, the privacy concerns of jurors and trial participants, and the dignity of the courtroom. Those are all fair. Mr. Kohberger and the state, to a lesser extent, urged the court to not allow cameras in the courtroom. They did. Everybody wants to close this courtroom up, which concerns me deeply. During a June 9th, we might have to physically move to Idaho. My children will be thrilled. During a June 9th hearing, the court heard argument from parties and interveners and observed that it had generally allowed cameras in the courtroom during both magistrate and district court proceedings. On June 23rd, the court entered an order reserving ruling on whether cameras are allowed in the courtroom, stated, the court is faced with the difficult task of ensuring the proceedings are open to the public while also safeguarding Kohberger's right to a fair trial. The best way to continue to balance these interests is to revisit the issues of cameras in the courtroom as the case unfolds. This court has the discretion to either allow or disallow video recordings of the proceedings. For now, cameras in the courtroom will continue to be allowed. However, that is subject to change by further order of the court. At the outset of the hearing on June 27th, the court instructed still photographers and video camera operators not to focus strictly on Mr. Kohberger if they wish to remain in the courtroom. Interveners and other longtime media outlets have followed the court's instruction. Kohberger, citing a small sample of unrepresentative still photographs, social media posts by persons who are not journalists or interveners in this case, and 2 out-of-context images from a video that plainly show wide camera shots, nonetheless asked the court to go against the standard of practice and remove cameras from the courtroom. Their argument is the court should continue to allow them. They don't address standing at all, do they? They sure don't. Let's see. Mr. Kohberger asserts the camera should be removed. According to him, 1, their operators failed to comply with the court's June 27th instruction. 2, some publications use these photographs with sensational headlines. Have you met the media? 3, these images provide fodder for non-journalist social media accounts. They'll just go into court and make those observations. 4, some camera operators focused on papers, documents, or notes located on or around defense counsel table. That shouldn't be happening. Mr. Kohberger's factual assertion should be rejected as his examples are not representative. It should never happen. Don't focus on counsel table, either counsel table. Just don't do that. Do they not talk to the camera operators? His legal analysis of the underlying constitutional issue is flawed because the primary case he relies on, Estes versus State of Texas, focuses on the number of cameras and obtrusiveness of the cameras in the courtroom, which are antiquated concerns over 50 years later when cameras are smaller and footage can be pooled. In short, Kohberger's arguments fail both factually and legally. His motion should be denied. So they're talking about the Estes case again, which we're not going to go through. Let's see. The camera equipment is dramatically smaller and quieter than it was in 1964 during the Estes trial. Yes, you're just like, it's just like a little camera on a stick at this point. Camera operators and their equipment are set up well in advance of any hearing rather than being carried in and out during the trial. Because you don't have to take the film out and run it to the news. This allows cameras and operators to become just another piece of furniture disappearing into the background. Let's see. Finally, Mr. Estes's conviction was overturned because the Supreme Court found the camera operator's conduct was distracting for the people inside the courtroom, not because the coverage was receiving attention outside the courtroom. That's a very good distinction. I like the argument. The distinction is, did this disrupt the trial? And it's like, that was 1964. The trial's not going to be disrupted by literally a camera on a stick against the back wall and 2 side walls, the way it's been in all the cases that we've seen. Courtroom camera coverage has not been focused exclusively on Kohberger and has been fair and balanced. The pool photographers and camera operators in the courtroom for June 27th and subsequent hearings have followed the court's instructions. For example, Court TV's coverage of the August 18th hearing in this case showed a wide angle of the courtroom, focused on the expert called by the defense when he testified, occasionally filmed close-ups of various participants, including the court and Mr. Kohberger, footnote 2. And then it's got the coverage links of all the different coverage, so I'm not going to read the footnotes because this is all different, just coverage link. Similarly, KTVB story covering the August 23rd hearing showed a variety of camera shots, including a broad shot that showed the entire courtroom, both counsel tables and the bench, close-up of the judge, a slightly zoomed-in shot of Kohberger and his counsel in which the Zoom feed could be seen, still shots of victims, and an interview of a legal analyst, footnote 3. ABC News, Good Morning America's coverage in August included a variety of shots. So they're just going through saying, hey, these are, we don't just focus on Kohberger's face. Mr. Kohberger argued that he is entitled to defend himself against capital charges without cameras focusing on his fly. Motion at 5. But no photographs or camera coverage focused on Mr. Kohberger's quote-unquote fly. We're now arguing about the man's zipper. Rather, one random X user, formerly Twitter, this is so confusing. Y'all, I'm letting you know now. I'm going to be calling it Twitter. It's just so hard. One random X user, formerly Twitter, X is a band. Stop it. It's also a narcotic. One random X user. In what context? Sorry. All right. Formerly Twitter modified a photograph showing Mr. Kohberger and a deputy entering the courtroom by cropping it into a very small size, focused on his belt, and adding a reference to Mr. Kohberger's fly. Right. Some Twitter user cropped a photo and was like, because people have too much time on their hands. Why are we focused on Kohberger's zipper? There's a lot more going on in this case. Even the crop photograph does not focus on Mr. Kohberger's fly, however, and Jesus Christ. This is in court. This is in court. This is in court. And interveners and the members of the public who are interested in but unable to attend the proceedings should not have their access to live court proceedings curtailed simply because of social media posts made by one or a few unknown and unaffiliated individuals. Your Honor, the internet. Have you met the internet? You can't get rid of all cameras on the internet because of a rando on Twitter. Stop. Removing cameras from the courtroom would have negative impacts. Removing cameras from the courtroom would have at least 3 negative impacts. First, it would force more news organizations to travel to Moscow to set up cameras outside of the courtroom, creating a much more visible media presence. Yep. Just like it did in the trial of Lori Daybell. Yep. The outside would get crazy. And every outlet would have somebody stationed in the courtroom, making it harder for members of the public to actually get into court because the media would take up a lot of the seating. They might argue that. Let me keep reading. Emily, keep reading. At Ms. Daybell's trials, cameras were not allowed in the courtroom, and instead, numerous media outlets sent their own still photographers and camera operators to set up outside the courtroom to do stand-up shots with reporters who had been in the courtroom for various proceedings and to capture various trial participants going to and from the courtroom. Second, removing cameras from the courtroom will not impede or diminish media coverage of Kohberger's case, but will lead to a significantly less accurate portrayal of the justice process. This argument. It will allow the pot stirrers on social media platforms to promote their made-up claims with no video coverage that can be used to dispute them with the truth of the proceedings. The social media coverage will inevitably turn further away from fact if cameras are banned and turn to rampant speculation to fill the void. Allowing cameras in court is an essential step in controlling the flow of accurate information. I don't think it needs to be controlled. I think you need to just let it go. Let it go. Just that argument. Third, removing cameras from the courtroom would make this case of significant public interest less accessible to the community members and family members who have suffered trauma as a result of the November killings. Also this was the entire basis in the Brooks case, that the community deserves to watch this trial, but the courthouse cannot facilitate the entire interested community. This courthouse cannot facilitate the entire University of Idaho community or the University of Washington community. This is 2 large university communities that have been deeply impacted by this. The courtroom cannot accommodate all those who would be interested in this. It would deprive the public of the opportunity to observe firsthand how the criminal justice system is working in this case. Public oversight provides, quote, significant community therapeutic value, including an outlet for community concern, hostility, and emotion. See Richmond Newspapers, Inc. versus Virginia. Camera access permits the press to report fully on judicial proceedings, serving as a surrogate for the public, most of whom cannot attend personally. In addition, polls show increasing support for cameras in the courtroom, including at the U.S. Supreme Court. Agreed. A C-SPAN Pierpont poll, whatever, found that 70% of voters agreed that allowing television coverage of Supreme Court proceedings would build trust in the court's process and rulings that it makes. It hopefully would build understanding. Oh, Paige, I'm sorry. WSU, not UW. That's what I meant. Apologies and thank you. I'm sorry. I apologize to the entirety of the UW family and the Washington State University family. Yes, I started law school in Seattle, so UW came out of my mouth first. Let's see. And this links to the survey. More and more courts are enacting rules allowing cameras in the courtroom. But they're all at the judge's discretion, and that's where we're at. We're at the judge's discretion here. Let's see. This is talking about Georgia allowing cameras in the courtroom. What Georgia does and what Idaho does are two different things. Interveners such as CNN and Court TV have experienced televising high publicity, high stake trials and doing so in the least intrusive manner possible. Court TV does a great job. They normally have the pool cameras and they do a good job. Finally, this court, for now, should deny or reserve ruling on the state's suggestion in its response of pleading that the court should not allow audiovisual coverage of the courtroom. Interveners well understand the state's concern for the well-being of witnesses, particularly in a case such as this one that has had dramatic impact on the university community, from which many of the witnesses will be drawn. But it is not the news coverage of court proceedings that has caused witnesses to be threatened or harassed, just as the decision to arrest a suspect or to prosecute Mr. Kohberger have not caused witnesses to be threatened or harassed. There are facts unknown to us, and I have questions. I have questions. Let's see. Other Idaho courts have allowed audiovisual coverage of trials with sensitive witnesses, and when the court has so instructed, the audiovisual journalists have followed the court guidelines to not film that witness. For example, during the rape trial of a former Lewiston Rep. Aaron Von Engler, photograph and video cameras were not allowed in the courtroom, and photograph and video cameras were allowed in the courtroom, and camera operators followed the judge's instructions not to record the victim's testimony. Because you can make rules. The young woman had been subjected to extensive and sustained harassment and threats by the supporters of the defendant, and then they go through other trials with similar concerns. That can happen. Easily happen. We saw it happen in the Brooks case where the minor witnesses were not recorded giving their testimony. Okay. That's fine. There's a balance there. Balance can be struck. So this is the media saying, hey, there's room for balance. We're asking for balance, not a full yeeting of every camera out of the courtroom. The defense has a response to that. The response was filed on the 12th. So we're going to go to that response, and then we're going to go to the court hearing that happened yesterday. All right. Let's swoop to the defense's response to the interveners. Defense response to interveners' opposition to motion to yeet cameras. It's becoming a mouthful. Oh, wait, we didn't. Hold on. I didn't finish. There were declarations. Oh, give me 1 second. But I don't know if there was anything in the declarations that they didn't cite the declarations a lot in the motion. Let me zoom. We haven't moved on yet, Chad. I'm sorry. I reverse course. I want to see the attorney's response. This is Rebecca Boone's declaration in support. I am the supervisory correspondent for Idaho for the Associated Press. And so this is talking about the ways that the press has been accommodated. Okay. I became a Loyola Law School Journalism Law School Fellow in 2012. That they have that? I didn't know that. That's fascinating. I also regularly serve as a panelist for training programs offered to teachers and journalists through a partnership between the University of Idaho College of Law, the Idaho Supreme Court, and the U.S. District Court of Idaho. I typically train attendees on the subjects including news literacy, how to access court documents, the ethics of covering the courts, how to incorporate the rule of law into press coverage, and why press access to the judicial branch is vital for an informed citizenry. I agree with all of that. So this is talking about how press pool cameras work, how press pool cameras are able to cover, um, adhere to the court's orders. Let's see. Press pools create a better informed public by providing credible and verifiable information about newsworthy events. I agree. They also build a historical record that can be immensely valuable for future scholarship, a role perhaps best demonstrated by the trial of the accused conspirators of Abraham Lincoln's assassination in 1865. The judge in that case initially barred newspaper reporters from the courtroom, but allowed the AP to hire the official stenographer for the U.S. House of Representatives to produce a transcript of the case, in case the censorship was lifted. The tribunal was open to news reporters on the second day of trial, and the AP news reporters' visual descriptions and notes paired with Francis H. Smith's transcripts informed readers across the country about the important court proceedings. The AP reports and transcripts effectively served as pool coverage for newspapers around the world and became primary source material for historians. That's really interesting. Francis Mears, Reporters of the Associated Press, Breaking News, page 59, in New York, Princeton Architectural Press. I am very interested in that. I have more questions. There are several considerations involved in creating a press pool. First, the news organizations interested in coverage of the courthouse event must get in contact with each other. They do that, forming the pool. They do that well. Then they must select the news outlet, which will provide the pool video and photo images and agree on distribution method. They seem to do that well. So they're talking about how you put together pool. I don't know if we need all of this. Once Court TV was selected as the video provider, the members of the pool began developing a plan to effectively distribute the videos. Different news organizations use different technologies for collecting and transmitting. So transferring video from one outlet to another in a timely manner can be challenging. It often requires extensive on-site equipment and specialized satellite trucks. It does. Court TV's video sharing equipment requires other news organizations to be on site to physically plug in and download the courtroom videos. As a result, Seattle Television and Como agreed to send someone with additional equipment to Moscow to collect video from Court TV. And they talk about how the pooling works. All of this is how the pooling works. All right. I want to see the lawyer's declaration, so we're going there next. It would be helpful if my page loaded. Oh, photos. Exhibits from the Boone trial. Look at the media presence. Declaration of Wendy J. Olson. This is the attorney. Here's the declaration. Attached as Exhibit 1 is a true and correct copy of the online news article that ran in the Idaho Statesman following the August 18th hearing on the case. Thank you, Attorney Olson, for attaching the article. Judge in Brian Kohberger murder case issues aggressive schedule ahead of October trial. Okay. Yep, that's true. That happened. All right. Can we zoom past this article? There's the prosecutor. Look, there are pictures. There are pictures of other participants in the court proceeding, which I think is their entire point. Declaration of Grace Wong in support of the intervener's opposition. I'm the senior director for courtroom coverage for Court TV. Hey, let's hear from Court TV. I've worked for Court TV for more than 20 years. I've worked for Court TV for more than 20 years collectively, the last 5 years since it was relaunched in 2018. Wait, there was a relaunch? I have questions. We're not going to do a history lesson today. I just internally have questions. Court TV regularly provides camera coverage of trials around the country. Yes, thank you. Court TV's professionalism has led to expanded camera access in courtrooms that have historically been closed to cameras. For example, in Minnesota versus Derek Chauvin, the Minneapolis, I pronounce that so weird. Minneapolis police officer convicted of murdering George Floyd, the Honorable Peter Cahill permitted live broadcasting with 3 cameras and multiple microphones, even though Minnesota restricted camera access. Judge Cahill imposed a ban on showing perspective and deliberating jurors. Everyone does. Put restrictions on showing victims' family members and minors without permission, and barred filming the defendant without his lawyers and prosecutors also in frame. Look, there's rules. Court TV served as pool, offering our feed to dozens of media organizations and broadcast the trial to a global audience. Live coverage of the trial was widely viewed as a success, and there were no violations by Court TV of the media order. Look, rules. In Court TV's more than 30-year history of covering trials, I'm unaware of any mistrials resulting from camera coverage. Indeed, some of the highest publicity trials have led to acquittals. Court TV served as pool for Casey Anthony's capital murder in Orlando, Florida, one of the most publicized criminal trials in my recollection at Court TV. I mean, also OJ. Even in the face of daily national press coverage widely publicizing her pretrial and trial, Miss Anthony was acquitted. It's a good example showing that it just because there's cameras in the courtroom doesn't mean someone's going to get convicted, right? It talks about the Rittenhouse case. Similarly, in Wisconsin versus Kyle Rittenhouse, the teenager accused of fatally shooting 2 protesters and wounding a third was acquitted of murder and attempted murder, with Court TV providing camera coverage prior to and during the trial. Ohio versus Husel, one of the biggest murder cases in state history. An Ohio doctor charged with 14 murders for overdosing patients with fentanyl was acquitted. Court TV and numerous other outlets provided live trial. And then they're going through trial coverage saying, look, these are the cases that we've covered. In O.J. Simpson, one of Court TV's first trials, Simpson was found not guilty of the murders of his estranged wife and her friend, with Court TV providing camera coverage. This is just a walkthrough of everything Court TV has covered. In New York versus Boss et al., 4 New York NYPD officers were acquitted for shooting an African-American immigrant 19 times after they mistook his wallet for a gun, with Court TV providing camera coverage. In Kentucky versus Brett Hanskin, Hanskin was acquitted of 3 counts of wanton endangerment in the botched raid that killed Breonna Taylor. Taylor was killed on March 13th, 2020. The trial was in March 2022, nearly 2 years after her death, with Court TV providing camera coverage prior to and during the trial. Court TV provided pool coverage of Jodi Arias' capital murder trial. In that case, the jury could not reach unanimity, which is always so hard to pronounce. Unanimity? Court TV did not cover her second trial, in which the jury was asked to consider only punishment. The jury once again could not reach a unanimous verdict for death. She was sentenced to life in prison. The Arias case received wide publicity before and after her trials. Her case spawned countless articles, books, movies, and several documentaries. Court TV covered the death penalty phase against Nicholas Cruz. In this proceeding, Court TV's pool coverage of the August 18th hearing included testimony from witnesses, the judge's rulings, the attorney's arguments, and Kohberger in context of the entire proceeding. So they went through quite a lot of high profile, high public interest criminal trials, saying in these criminal trials, the outcome was not a foregone conclusion. It's even in high profile cases, there have been hung juries, acquittals. So it's not a foregone conclusion that if there is a camera in court, it's going to sway the jury one way or the other, which is a really interesting way to lay it all out. I wonder how they're going to argue that when we get to court. So what's next? What's next? We just have to go to court, right? That's it. We just go to court. So let me change over the way my windows are laid out so that we can do full screen coverage. Let me make sure my audio is we're just going to turn it all the way up. We're just going to put the tab booster on all. And this was yesterday's hearing. I know there was a Murdaugh hearing today. We're not getting into it today, to those asking. We will get there, just not today. Let's get to Kohberger's hearing from yesterday. It's about a 45-minute hearing. We are going to Court TV's cameras for this. Hopefully the audio is not absolute, complete crap. Let's go to court. Did we do the state's response? Yes, we did. Yes, we did. All right. Let's see. Let's swoop. Let's swoop and go to court, shall we? Time to go to court. Hopefully you can hear better than me. I need to replace my audio. All right. I will make myself small and big, depending on what's needed. We will embiggen and ensmallen appropriately. And let's go to court. And then we will do Q&A. Of all the hearings I've seen, it's all on a potato. All right, let's go. I can't hear anything. Oh, good. Oh, good. Let's speed up until people come into court. Defense attorney Ann Taylor's in court. It is low here. Let us speed up till all the participants get into court. There's the deputy. There's the defendant. Which means we will be starting soon. I'm going to leave this at normal speed because it's about the best we can do. Let's see if I can make the... Oh my God. That is so hard to hear. Let's see if I can make the closed captions look better though.
All right, well, good afternoon.
You've got to be joking me. Can any of you hear this? Good afternoon.
Let's get on the record, please.
Oh my God. All right, give me 1 second. That's awful. Yeah, it's so low. I'm going to see if this changes. If not, I will switch feeds. It's so low.
Thank you. We are now on the record. Stop.
Nope. Thank you. We are now on the record. That is abysmal. Court TV, we tried. We appreciate you, but that's not happening. Not at all. I can't hear anything on that. All right, let's see if we can find that hearing. Let me go to one other video for that. All right. We're just going to have to deal with the background noise because that's the option is either background noise or we can't hear anything. So, all right. Let's hope this is better. Fingers crossed.
Let's get on the record, please.
That's minimally better. Make sure we have our closed captionings up. Let's see if we can make those look a little better.
Thank you. We are now on the record. Stop. Only on your computer. I'm moving around. No, I disappeared.
It's so low. Oh, I did, didn't I? I did skip the defense's response. Because I was like, oh, we're done. I went back. Here's what happened. I went back to do the I went back to do the declarations and then I moved on when I shouldn't have. Okay, give me 1 minute. Let's go back to that. Thank you. See, chat is bay. This is why we live stream. We just crowdsource. Let's do that real quick and then we will. It's a pretty short response. Thank you, Stephanie. Sorry, Miguelina. Timestamping is now a joy. We're just going to skip me trying to find good audio because it's never happening. All right. Let's do this real quick. That looks weird. Let's see if this looks better. A little bit. Where'd it go? Come back. Lordy. We're ready for retrograde to be done over here. I don't know about y'all, but I am ready. All right. This is defense's motion. Understandably, they say, the media's opposition cloaks itself in the mantle of public good, purveyors of the inner workings of our government. Were it only the kind of cameras used to show the workings on the House floor on C-SPAN, Mr. Kohberger would not have needed to make this request. That's a fair point. What defense is saying is, had the cameras just been stationary and showing the whole floor, it wouldn't be a problem. The media wants to make money, and it does so by making a spectacle of Mr. Kohberger and everyone involved in this case. In pursuit of its desires, the media makes two basic and incorrect arguments. Estes, Texas was not limited to concerns about the impact of the number of cameras and obtrusiveness of camera equipment. And Chandler versus Florida mandates expulsion of cameras from the courtroom. Mandates expulsion? That's strange. With regard to the first argument, the characterization of Estes as being concerned only with the disruptions posed by the logistical implications of the courtroom filled with the press observers is a partial reading of the case. Indeed, it appears the media simply stopped reading halfway through page 536 of the opinion. Snappy. The defense is snappy. The rest of the opinion goes on to consider the larger issue at stake. The television camera, this is quoting the case, quoting Estes, quote, "The television camera is a powerful weapon. Intentionally or inadvertently, it can destroy an accused and his case in the eyes of the public. While our telecasters are honorable men, they too are human. The necessity for sponsorship weighs heavily in favor of televising only notorious cases, such as this one, and inevitably focuses the lens upon the unpopular or infamous accused. Such a selection is necessary in order to obtain a sponsor willing to pay the significant fee to cover the cost in return a profit. We have already examined the ways in which public sentiment can affect the trial participants. To the extent that television shapes that sentiment, it can strip the accused of a fair trial." Interesting. Interveners argue that the Estes course concluded that camera coverage so distracted trial participants as to deprive Mr. Estes of a fair trial of his conviction, and that Estes's conviction was overturned because the Supreme Court found the camera operator's conduct was distracting for people inside the courtroom, not because the coverage was receiving attention outside the courtroom. The argument again is flatly contrary to the Estes holding, which is expressly extended to pretrial coverage and was additionally concerned with what each juror would carry with him into the jury box as a result of their exposure of pretrial publicity or prejudicial publicity prior to becoming trial participants. That's going to be a concern in every case that's covered. That's a concern for people reading newspaper articles or listening to podcasts. Cameras or no, that's always a concern. Indeed, the procedural support chosen by the media for their interpretation of the Estes holding is Chandler versus Florida, which has to do with whether there's constitutional rule against coverage. It would be rather odd for Chandler to worry about coverage if Estes was a case about too many wires in the courtroom, as the media claimed. In any case, Mr. Kohberger asks for no such per se rule. To the contrary, the prior motion cited those factors now ignored by interveners' flawed interpretation of the Estes decision. Snappy. Let's see. In particular, the Chandler court emphasized Justice Harlan's conclusion that there is no constitutional requirement that television be allowed in the courtroom. And at least as to the notorious criminal trials such as this one, the considerations against allowing televisions in the courtroom so far outweigh the countervailing factors advanced in its support as to require a holding that what was done in this case infringed the fundamental right to a fair trial assured by due process. Let's see. Interveners misrepresent their compliance with the court's order. They're like, we're not focusing exclusively on Kohberger. And they're like, but you are focusing on Kohberger some. Admitting that press observers have violated the terms of the court's prior order, interveners nevertheless contend that because their observations and coverage is occasionally non-violative, defense counsel's concerns are unjustified. First, it seems relatively obvious that the easiest way to fix the counsel table issue is to move the cameras. There is simply no reason cameras need to be placed so they have a clear view of counsel's laptops. That's fair. Move the cameras. I agree. Fine. Mr. Kohberger is not required to accept promises that no one is going to zoom in on contents, capture them in a high enough resolution that someone else can zoom in on them and post it online. That's fair. Then move the cameras. Second, the media and social media users' behavior is likely as uncontrollable outside the courtroom as they admit. As they say, even without cameras, they will simply go on using old images, yet the media prefers new images because human beings crave novelty. We've gotten far afield here in this. The media knows the outlet with the latest scoop wins. The social media users constantly post any new information they get about this case, not which just vaguely motions at social media. Images from court are no different. Thus, to say there would be no effect would be inaccurate. A reduction to the novelty of images would have the beneficial effect of focusing the public on the facts of the case. I feel like we're focused on the facts of the case. Like, you're mischaracterizing the law nerds. I'm teasing. They're not talking about us. There is room for conversation about a case that's not over sensationalized, overhyped. Moreover, federal courts do not permit cameras, yet the public remains well acquainted to the facts of many federal cases. I think there's a lot of questions about the facts of many federal cases because there are no cameras. That's part of the problem. These proceedings are not entertainment. I mean, gladiators. The chief function of our judicial machinery is to ascertain the truth. Yes, and I think people want to understand. And I think they see it as, I want to know what's happening in this case. I want to know what's happening in this case. Also, sometimes the lawyers are very entertaining, even when they don't mean to be. The use of television, however, cannot be said to contribute materially to this objective. It can, though. It can protect the case, I think. Rather, it uses, I hate this font. Rather, its use amounts to the injection of an irrelevant factor into court proceedings. In addition, experience teaches that there are numerous situations in which it might cause actual unfairness, some so subtle as to defy detection by the accused or control by the judge. That's from the Estes case. They accept benefit as intervener's note of the accepted benefit as intervener's note. I hate this font of unfettered press access is the preservation of the provision to the public, quote, of the opportunity to observe firsthand how the criminal justice system is working in this case, and the ability to observe each step of Mr. Kohberger's prosecution. Yet implementation of the requested restriction is not as draconian as interveners seek to portray. You want to yeet all of the cameras. That feels heavy-handed. The removal of cameras from the courtroom does not render this case closed to affected community members and the public. It renders it effectively closed because the courtrooms are small and there will be so many media members that the community will get pushed to the side. That's what happens in all of these cases. The community gets pushed to the side because the media is going to force their presence one way or the other. Less media will show up if there are cameras because they can cover it from footage. Indeed, those most affected due to interrelation and with and physical proximity to the community would remain able to observe proceedings in person and would therefore be the least affected. Not if the media swarms the courtroom. All right. That's what the defense wants. That was their response. Hopefully we get as much audio as we can. It's low. I have boosted it as much as I can. I hope as the proceeding goes on, it gets a little bit better. We're all just going to keep our fingers crossed. I have it boosted everywhere I can have it boosted. So, and I've got closed captioning on, and we will do our best. So let's go again to court in Idaho. Fingers crossed, y'all.
Okay, good to go. Let's try this again. Can you hear me?
Oh, they're talking to the Zoom.
Yes, Ms. Massa? Yes. Okay, excellent. Okay, we are now on the record. This is State of Idaho versus Brian Kohberger, CR 2922-2805. Mr. Kohberger is in court with counsel, Mr. Logsdon and Ms. Taylor. Ms. Masseth is participating or observing from Zoom or through Zoom. The state is represented by Mr. Thompson and Mr. Rudley. also who are in the courtroom, and Mr. Nye and Ms. Beatty are
There we
Zooming
go.
through Zoom. We also have Ms. Walt.
He's calling roll
Olson
of who's
and
there
Mr.
and what they're
Malone,
doing.
representing the
I'm glad I found the
Media
font options.
Coalition. And Ms. Towler is court reporter.
There we go.
So,
All right.
Welcome back, everybody. And I think what we need to do is first address the motion to intervene.
Yes.
So, Ms. Olson, is that for you?
Motion to intervene first,
It is, Your Honor.
Thank you.
or the intervener's motion.
Your Honor, as with the motion that proposed interveners filed before the court, we seek to intervene for the limited purpose of opposing the defendant's motion to remove cameras from the courtroom. It's our position that the proposed interveners are the ones who are most affected by that particular motion. And in light of the court having asked us, essentially the same group of interveners.
I know it seems like the typing has stopped. It seems like the typing has stopped. It's good. It's good.
To weigh in on this issue before, we would seek to intervene again just for that limited purpose of opposing removing cameras from the courtroom, Your Honor. And I think it's in the court's discretion to do so.
All right, thank you. So I see this. Oh, don't go away. No, I want to talk to you about
Okay.
this.
Of course, like Ms. Olson, come
I
back.
think that, well, I'm not sure, okay, that this is the same intervention as we had the.
On the
first
non-dissemination
round. I
order.
think this is a different situation. And
I know the
think
clock and the
some
frame rate of the camera
comments,
aren't working
kind of
together.
jumped the gun a little bit, thinking that they are interventions or interveners. And I mean, you know, this was filed on August 30, 2023, so we really haven't had a chance to talk about this. And I haven't addressed it in court, as you know. So, and we already started with the merits, okay, before I have approved the intervention. So,
Rebecca, that's an excellent
my
point.
issue first is really on the standing, because the first round had something to do with Constitution, state Constitution, U.S. Constitution, and I'm not sure that
Standing.
applies in this situation.
All right, Judge.
45, and I think that the Supreme Court, the Idaho Supreme Court, sort of addressed that a little bit in the former motion for mandamus. So, you want to address that, the standing issue first?
Sure, Your Honor. With respect to the Supreme Court's decision, when we filed a petition in front of it back in January, I think they said that the media has the right and should be able to intervene when there are issues related to First Amendment issues and access issues. And Your Honor, I would submit that, and we understand that ICAR 45 is absolutely the governing piece of law on this. But when we talk about press access to the proceedings, cameras in the courtroom, I would submit, Your Honor, are part of that press access to the proceedings, because it's the cameras in the courtroom, it's the ability to have pool coverage, it's the ability to have still photographers that provide access to a much greater number of people than even having just the reporters who are going to write things down and post stories after the fact. It allows sort of that broader access that allows people to see sort of firsthand what is happening, and we think that's an important First Amendment right, Your Honor.
Sorry, that was my mic. The court is not keeping press out of the courtroom. When keeping cameras out, it's not keeping press out. So I don't think they're going to get to this First Amendment article or First Amendment argument, because they're not keeping the press out. The press isn't being limited other than cameras. So I think it's a bit different.
That's a First Amendment right to have cameras in the courtroom?
No, Your Honor.
No.
Press access is absolutely, and public access, I think, is absolutely a First Amendment
He's
right.
not limiting
So
public
the press
access.
and the public have full access to this courtroom.
I
He hasn't
agree, Your
closed the
Honor.
courtroom.
Having cameras in the courtroom, having still photographers, having live coverage allows that public access to be much greater than it is.
That's
to
not
just
the
having
standard.
people having to travel to Moscow, having to come into this particular courtroom, Your Honor.
That's no,
I am empathetic to the media's argument, but that's not the standard, right? Me personally, I want cameras to remain in the courtroom. But when the defense and the prosecution are all like, no, it's a hard argument. And she's like, the press absolutely has right to the courtroom. And he's like, I'm not telling you the press can't come in. I'm saying there might not be camera. And that's different.
implication for the United States Constitution or the Idaho Constitution. I
Your
just
Honor,
want to clear this issue up in terms of
Oh, no.
what the standing is.
Yeah,
Your
she hasn't
Honor, I
addressed standing.
respectfully disagree because
She's like, this is a First Amendment issue. And the court's like, can we get back to whether or not you actually have standing? Please. She didn't address it at all. Like, how do you have standing to be here? How do you have standing to be here?
I think that the First Amendment and the Idaho Constitution both contemplate this right broad access piece of it. And I think there's an argument to be made that having cameras in the courtroom takes a step from that right of public access and makes it more open to additional people. So I think there
Yes,
is a
about
First
standing,
Amendment
ma'am.
there. It's certainly not as strong as, for
Tell him how
example,
you have
if
standing.
proceedings, there was some sort of what was
Olsen,
opposed to proceedings.
standing.
No journalist could come into the courtroom. I think that would be a far more significant problem, Your Honor. But I think in terms of First Amendment interests, the broader, and maybe because there's some access already, the First Amendment interests are smaller, but I think there is a First Amendment interest in having broad access to the court proceedings. I think it's also in the interest of the court, Your Honor, to make that access as broad as possible, because we're unfortunately in a day and age where for some people, if you can't see it, you don't believe it, or if you can't see it, it didn't happen. And there's an increasing need for people to see for themselves precisely what's going on inside the courtrooms of this country.
Are there cases that support that?
That support cameras in the courtroom?
No. And that is based
Standing.
on constitutional law.
Well, Your Honor, I would say that the line of cases that we both cited, Estes in Chandler.
She's trying, but no, there is not case law that says cameras in the courtroom are a fundamental constitutional right of the media. The media has right to access. She is trying to argue that access includes cameras in the courtroom, but I don't think it does. I don't think it necessitates it. I think it maybe should, but I don't think it does. But she still hasn't addressed the issue of standing. And I don't know if she can.
Versus Florida says that there's no prohibition on having cameras not in the courtroom. There is not a case that says flat out, under the First Amendment, there is a right to have cameras in the courtroom.
Right. Of course there's not.
Well, I understand that.
The judge is like, yeah, I know. We still haven't talked about standing.
Let me, because I was looking back at this decision that the Idaho Supreme Court made, and
This attorney
It
has an
does
uphill battle.
say
She's doing a good job, but
that,
she has an uphill battle.
petitioners, meaning you
So.
in that case, or your clients, I should say, are correct that Idaho's rules of criminal procedure do not provide a specific mechanism for third parties to intervene in a criminal case.
Look how small the camera is. Oh, wait, let me
Likewise, the
move.
federal rules of criminal procedure
Hold on, let me move me out of the way. And you can see the camera right above the logo for the network.
do not
You can
provide
see
for a
that
motion
camera
to
is just kind
intervene in a
of
criminal
there right on a
case
little tripod.
brought by the United States, of course. You know that.
Really, really unobtrusive.
It says, however, both state and federal courts often permit the media to intervene in criminal cases on a limited basis, or at least file a motion as interested parties.
He's trying to establish standing since she has still not answered the question.
The defense of public access and free speech, including in Idaho. So I think, I mean, we're on the same page on that, and I understand that. This idea of intervention specifically versus as an interested party, because I know in the Daybell case, the media was characterized as interested parties.
Okay, then call them interested parties. That's fine.
I'm
They are
just
interested.
not sure that we get all the way to intervention, because historically anyway, my understanding of the rules is intervention means you are really a party in the case. And that gives you significantly more access. I'm thinking about this more as an amicus brief or presentation, because I'm willing to hear it. I'm willing to read the briefs. I think that's important, but I'm not necessarily comfortable going to call it all, or the media coalition to be interventions. So do you see a difference there?
Between interveners and interested
Your
party?
Honor, I understand the difference, the distinction that the court is making. That's why our motion.
If you wonder if lawyering is sometimes splitting hairs, what they are talking about is what is the difference between an intervener and an interested party. And at this point, I think they probably should just go with interested party, but they had previously gone with interveners because they were granted the right to intervene, like actually come into case and intervene. At this point, I think we've gone back to interested parties because they're not being kept out of anything. So this is the legal hair splitting of, is the media allowed to come in as an intervener? Are they actually allowed to intervene? Or is the media coming in as an interested party? And the position of the media is different now than it was at the appeal stage, because at the appeal, they were appealing being kept out of information. So they were seeking to intervene and have the court change their ruling with regard to that non-dissemination order. Here, I think they're more interested parties. And I think that's appropriate because you don't get good answers to questions unless you get good questions. And the court is trying to narrow down the question. What is the question? What are these parties? What is their standing? So the court is narrowing and narrowing and narrowing down to get to the right question, because you can't get to the answer until they are, well, tailored into the right question. So are you an interested party? And I think the media at this point is. And yes, they can still file motions as interested parties. It just changes. So yes, they can. They can still be an interested party and file, and the media is allowed to do that at times.
Intervene has always been for a limited purpose. And you know, full candor, this was a difficult one to sort of try to solve procedurally. It's been my experience in Idaho state courts that rules and cases.
That's kind of funny. We really do attack with books. Jordan, I love this. Someone posted a TikTok calling attorneys attack librarians, and I cackled. It's fair. It's fair. Let's see. Is this hearing from yesterday? This is a hearing from yesterday because the hearings are released on a delay. This wasn't released until last night, so we are covering it today.
I read very literally, and we couldn't find a rule, so that's why we went to the Supreme Court to begin with, because there wasn't a rule that allowed us to do that. And I think for purposes of the proposed interveners, the media coalition in this case, that being allowed to present its argument to this court, whether it's as interveners for a very limited purpose, and that's without a rule, that's typically, I think, how you would get in.
Or as interested
Into
parties.
a case, I was trying to liken this to, like, you know, motion to quash a third-party subpoena, but there's a rule that allows you to come in and challenge that. So when there was no rule, we were trying to identify, well, what is the procedural mechanism? And intervention is typically, certainly there's a civil analog, and there's a way to, that's just the analog that we requested from the court before. We think it's consistent with what the Supreme Court said in the case that it decided in April. But if the court does not want to give us intervention status, I remember we had that discussion a little bit last time, and we asked you to sign the order, so in part that would be precedent for us to do this, and you did.
Yeah.
But
Everybody agreed, so I signed it. But now I've thought more deeply about it.
Yeah, and I think
Judge is like, yes, everyone agreed, so I was fine, but this is different. So now I don't necessarily agree. I have slept on it. I had thoughts in the shower, and now we're back. Because always the shower thoughts, or the thoughts in the shower.
Would rather the media coalition appear as interested parties, And that would also serve the media coalition, and we'd be happy to present argument just as interested parties so that there is some entity speaking for continued access in the courtroom.
Okay, I could even label you as media coalition.
That would be fine with us, I think, Your Honor.
Okay, great. And there is some language, and I don't need to read it now, on page 14 and page 15, that kind of caution going too far with intervention, or what we call it. And I'm trying to clarify this a little bit. I think the Supreme Court is trying to clarify it a bit in criminal cases. And my reading of this is they really don't want the media to just be coming into the middle of criminal cases to, I guess, exercise their concerns.
And I don't think the media wants to either, Your Honor. I think both with the initial motion to intervene and the issue that was raised last time about the non-dissemination order, and for this issue with respect to cameras in the courtroom, those are both about sort of fundamental access to the sources of information that this trial, this proceeding are really all about. And so that's, I think, the media doesn't want to have to, they don't have to pay me, Mr. Crump, every time they want to make an argument in court, and we don't think that would be appropriate either. It's just those issues that really fundamentally affect what sources of information they can access in the process of reporting on this court, Your Honor.
Okay, great. Thank you, Ms. Olson.
Thank you, Your Honor.
I'll give you first. Mr. Dudley?
No. Well, Your Honor, the state has no objection to either classification of the media for the limited purpose of helping the court decide this issue.
The prosecution's like, I don't give a shit if you call them interveners or interested parties. Can we get along, please? We have a lot to do. I don't care. And the state doesn't want media in the courtroom anyway. So they're just like, Your Honor, whatevs. Okay.
Okay. Thank you, Mr. Dudley. Okay, Mr. Logsdon?
Yes, we're not going to object, obviously, to hearing from the media, and I certainly understand the court's concern, and it's interesting, but and so long as I guess they're not filing things willy-nilly and making discovery requests.
Willy-nilly has come up in this court a lot. He's like, so long as they are not filing things willy-nilly, then we'll get there.
We're not terribly concerned about how they're doing.
The defense also doesn't care how they're classified. Great.
Maybe I'm just being a little nerdy about,
Yes.
Rule.
If you didn't hear the court said, maybe I'm just being a little nerdy about it, about the rules. But the court is like, the Supreme Court has said this, and this other rule says this. And he's very, as lawyers get, especially as judges get, very interested in the fine tuning of the law here. And so when the court's like, maybe we're a little nerdy. Yes, sir. Yes, Judge, you are. But we appreciate you thinking it through with precision.
Rules and, even the history in Idaho, and also relying on some of the language in the petition for writ of mandamus that the Supreme Court issued on, I guess it was April 24, 2023. So I really think it's more appropriate, and I looked into this to some level, and to serve an amicus brief, but not considered as a party, as an intervention, but sort of a presentation or brief addressing particular issues of interest that are important. No question about that. So that's how I'm going to view this, and I'm going to deny the motion to be for intervention. I don't know why I'm having a hard with that, but however, I will certainly consider the arguments, consider the briefs, and I will consider that while balancing the concerns of both the state and the defendant too.
So what the judge just did was, I am denying relief as an intervener. You are not a party. You cannot just file things. You are not intervening. However, I will consider your arguments. And this is more like an amicus brief. An amicus brief is a friend of the court. Like, hey, Your Honor, we're interested in this case. We're an interested party. We're an interested party for a reason. We see this in the Supreme Court. We did the amicus brief from Mischief, and in the Jack Daniels Bad Spaniels case, because they're like, we are an art collective. We are interested. We do this type of art. The ruling can impact us. And that's here. As a friend of the court, your ruling would impact the media coalition, and we would like to be heard as essentially an interested party, not an intervener, not someone who is a intervener party to the case. So he's just redefining how they are. But yes, I'm going to hear you out, but I'm going to not grant you status where you are now a part of the case, if that makes sense. We did the one by the Onion as well. Yep. So hopefully that makes sense.
So let's move then to the arguments.
So now to arguments.
In the courtroom, and we'll start with Mr. Kohberger's team, and I believe that's also going to be you, Mr. Logston.
So Mr. Logston's arguing for the defense.
Take a lot of time. We've briefed this. Moreover, we somewhat argued it a few months back. I think our position is that the court, I think, understands our concerns about turning this into a spectacle, the way that that may prejudice the public against our client, the way in which that dehumanizes people, constellation, and turn this into more of a TV show drama than a court proceeding, which is what it is. And I think everyone understands that. Our concern is that since that time, it doesn't seem like much has changed. The media's argument, as far as I can understand it, is that the cameramen that are here are doing their jobs well. There are editors for various organizations or people on social media that take those images and then do things with them that we may not like.
Mr. Logston? The internet's going to do that either way. Sir, the internet's going to do that no matter what happens.
And that if the court removes the cameras, presumably those people will just use older images, and we won't have affected things and fall very far. Our position is that the removal of the cameras does two things. One, it stops new images, and I don't think we can underestimate the power of novelty when it comes to what the public is interested in. Use of
He's just making the same arguments he made yesterday.
There's a reason why we live in a world of memes where people are constantly trading around pictures. They quickly get old. There's a new one. It seems like every day there's
Memes are funny.
hundreds of brand new images. So the concept of removing
We like memes.
this sort of almost
Sir, we like
sideshow,
memes.
from what's being put out there, we think would be an important way to kind of take away the sensationalization of this case and just kind of reduce it to hopefully the words on the page. And if they're using old photos, et cetera, you can't stop them. But we just don't see that as being as big an issue as a constant stream of new images that are being manipulated, et cetera, to make viral content, what have you. Our secondary point is just that we don't like where the camera is currently sitting because it looks like where I'm sitting and my laptop. I got one of these fun screens so that if you look at it from the side, you can't quite see what I'm doing anymore. But it's a distraction for us because we feel like essentially there's a camera right over our shoulder, and we certainly understand they're not zooming in on.
So there is a camera over your shoulder, but if you allowed cameras, you could put camera by where the judge is, like behind the court reporter, next, like between the court's bench and the witness bench. You could put one there that would face your face if you would just allow someone to face your face, or put them in the the jury box to face your face on the other side of the courtroom, and then they wouldn't be behind you over your shoulder. Just put the camera somewhere else.
What we're doing, but I think we've already seen that once they make these images and they pass them around, I mean, they're all make cameras, and somebody else could presumably do that. And so that causes us quite a bit of concern as well. So if the court decides that removal of the camera isn't necessary, we do have, I think, a bigger concern of just making sure that they're set someplace where we don't have images that are really just what we're working on during the case. And I don't really have much else to report unless the court has questions.
I have one comment or question, because in one of your briefs, I know I've had two sequences of briefs because we had this earlier, but this was a newer one where you were saying, well, this is a quote, were it only the kind of cameras used to show the workings on the House floor on C-SPAN.
I may be showing my age, but they might have better cameras now, but when I was
I'm sure.
younger, it was just this camera like.
Sir, let him finish. Counsel, let the judge finish his thought. He was going to ask you a question. He was going to ask you a question.
Way over there.
Yeah, well, that's the point. I mean, I made me think about that, is just plant a camera up there. If everybody can just see what's happening from the back of the courtroom, maybe that can satisfy everybody just partly.
Sure.
That was kind of my idea, Judge. That was my suggestion.
Here's my suggestion. See the space between where the judge is sitting and the witness box? There is a spot. Just put a camera on a tripod in that spot and face it out towards the courtroom. And then you'll just see everybody. Same as in the Paltrow case. Set it next to the witness box, do a broad view of the entire courtroom, and don't zoom it and don't pan it. Just do a wide view shot of the courtroom, and that's it. Just do that. All of that. And don't zoom. Don't move. Don't do anything. Just camera. And then have maybe one in the back facing the judge so you can see the judge when he talks. That's it.
I feel like somebody's going to throw a tomato at me, but that, I thought, might be a way to kind of give a little and just kind of protect.
Sure.
No one's throwing tomatoes at you.
I've never seen anything very sensational on C-SPAN.
That's literally what I was thinking.
Yeah,
Although Newt Gingrich got pretty close.
Yeah, there you go. Okay, well, thank you.
Thank you, Judge.
Okay, are we going to Mr. Rudley now? Ms. Olson gets at the end of that, and then I'll go back to the parties. Go ahead.
This is a great point. If the defense is willing to compromise, why ask to have all cameras removed? Right?
Thank you, Your Honor. As we previously discussed, the decision of whether to allow cameras in the courtroom is discretionary for the court. The state outlined our concerns with allowing cameras in our responsive brief and in our June 6th briefing. Primarily, those concerns are preserving the right to a fair and impartial trial for all the parties, protecting sensitive witnesses who will testify at hearings and trial in this case, and safeguarding evidence, which is the graphic nature. We agree that the media plays an important role in the court process.
You do?
And we appreciate in their briefing the measures that they identify to address some of our concerns for protecting vulnerable witnesses or evidence which is of a graphic nature that they've done in previous cases. However, our contention is that the safest way and best way to address all of these concerns is to prohibit cameras in the courtroom, or in the alternative, prohibit cameras when sensitive or vulnerable witnesses are testifying or there's evidence being viewed that's of a graphic nature.
And that evidence should not be on screen ever. Agreed. Fine.
Thank you.
That's fine. Absolutely agree.
Okay, Ms. Olson.
Thank you, Your Honor. And I think, legally, we're where we were 3 months ago with respect to what the rule the court has to consider in terms of whether to continue to allow cameras in the courtroom, and that's Idaho Court Administrative Rule 45. And I think, Your Honor, when we read through that rule, it really addresses the concerns that the parties have raised to this court about what the court's discretion is, about what it can, how it can direct cameras, where they're to be in the courtroom, all of those things, that it can restrict camera coverage when there is a particularly sensitive witness. And I think, Your Honor, what you saw in the declarations that we submitted, the declaration of Rebecca Boone and the declaration of Grace Long, is that these are journalists who are experienced in covering court cases, and in covering court cases where there are cameras, both video cameras and still cameras, and following the court's admonitions about what can be covered and what can't be covered. And I think, particularly, Your Honor, with respect to Ms. Boone's declaration, and Ms. Boone, who is a graduate of the University of Idaho's journalism program, who continues to be an advisor to that program, and who certainly would have not only the best interests of her employer at heart, but she understands this community. I mean, her experience has been that when you have these pool cameras, both still and video, and when you allow camera coverage to the extent that you can, it better serves the public, and it helps ameliorate the kind of media scrum is probably not the term that my clients would want to use, but this.
I think she said a media scrum is what they're trying to avoid. I think that's exactly what they're trying to avoid, is a media scrum. That's exactly what they're trying to avoid. Sam asked a great question in the chat. So as we are pausing to envision a media scrum, if you're not familiar with rugby, the word kind of describes itself, but that media swarm. Can sensitive or vulnerable witnesses not give testimony by camera link from another room? Generally not. The defendant has a right to be confronted by their witnesses. You have a right to see the witnesses against you. So remote testimony in criminal cases is generally not allowed under most circumstances. Some limited circumstances were shifted during the pandemic, but it is not easily done, and it is not it's easier to say, no, the cameras go down for this testimony, or the video goes down and it's audio only for this testimony. That is a much easier guideline, but no, they cannot generally. So.
For that big gaggle of journalists who accumulate outside of the courtroom when there is no opportunity to be inside
She went
the
from scrum
courtroom.
to gaggle.
When you don't get the opportunity to have that full procedure. So I think the court can use Idaho Court Administrative Rule 45 and craft a solution that continues to allow the journalists who are working hard to cover this case to be able to do so in a way that both allows them to provide really a firsthand account of what's going on. And again, Your Honor, I don't think we can
That depends on the jurisdiction, not in all jurisdictions, but that depends on the jurisdiction and on the case and the nature of the case.
Estimate the importance of that firsthand video account as well, because we're just in this day and age where people are used to seeing things firsthand. There's cameras everywhere. To be able to really have great confidence in the proceedings.
There are cameras everywhere.
Court that allow some sort of in-courtroom camera coverage.
I think the media kind of broke that for themselves, and now people are like, just show me the video, just roll it, don't edit it, don't cut it, just roll it. Like, just people now just want to see for themselves, and that's true. And I think it's fair. People have questions
Of the proceedings. People are going to need to be able to see firsthand for themselves how the evidence is presented, how they want to see the rulings in court. They can learn a lot from that.
What they want, though, is not part of the rule.
Are in the courtroom and they go set up outside and they talk about what happened. And so I think that's a good reason to continue the policy that the court has had. And then I think, Your Honor,
we've gotten to the policy arguments because the legal arguments aren't that strong.
The violations of the things that the court said at the outset of the June 27th hearing. Now, I was not here. I read about it in the attachment that Mr. Logsdon made to his initial, or the reference that Mr. Logsdon made to his initial pleading in this round. And my reading of that, Your Honor, it's actually in a Fox News story, is that the court said, and of course the court said it, so I'm sure the court's memory of it is the best, but that the court made a comment that the court should, or some having a hard time.
Back up. Back up. That's what I said. That's one of the things I said.
Yeah, okay.
It was just focusing
Right.
too much in particular areas, and so I was just cautioning the media to step back, and they have pushed the envelope.
Yeah.
I'll tell you that.
Okay. Well, Your Honor, I think that what the media heard on that occasion, as reported by Fox News, was that the cameras needed to show a wide shot of the courtroom and not focus strictly on Mr. Kohberger. And I think that phrase focus strictly on Mr. Kohberger has clearly been interpreted to mean you can still take pictures of Mr. Kohberger, but he's not the only one you should be taking pictures of. And there's certainly a limitation in print media or the online stories. I mean, you don't always have video. So what I've seen, and I think that the examples we provided to the court, where there were pictures of lots of different participants in the courtroom, and they're trying to show everybody. And if the direction from the court is instead, look, there can be no single pictures of Mr. Kohberger, the challenge is, and I think even Rule 45 says this, there are some limits on how much the court can tell the editors and everything, because they're not here in the courtroom, and some of those people may still choose to crop out just a little bit.
She's arguing that there are limits on what the court can direct the media to do, but that doesn't help you, because the court's like, you're right. I can't limit that a social media user might take a picture like this and then crop it in a certain way. So no pictures. Like that, I don't think it helps. But if the issue is we don't want camera operators zooming around and we don't want them zooming in on Kohberger, put a camera in the front of the courtroom and a camera in the back of the courtroom and just do that.
Of that picture. And Your Honor, I don't think that runs afoul of what the court has in mind. I think that what you've seen is an attempt by the journalists who are here in court to show a wider shot. I mean, as we wrote in our brief, from that courtroom angle there, I mean, it's, I think I said it's not a football field. It's hard to get sort of the full perspective where the camera is sitting right there. If there's a way to station the camera at the very back of the courtroom, maybe, but those are also the things, like you saw this in this.
Put it between where the bench is and where the witness stand is. There is a gap. Put a tripod in it. This is not rocket
The
science.
court TV people have a lot of experience working with courts and trying to find the best way to both serve the purpose of having cameras in the courtroom
Yes.
and being able to present to the public the proceedings as they occur, and also not be intrusive,
Yes.
not cause noise, not run afoul of the court's admonition to focus in on any particular individual. So they are more than willing to work with the court to do that. They just ask to be continued to be in the courtroom, because I think when we look at the full media coverage, they haven't run afoul of that admonition.
Like, this coverage is fine. You can see the whole courtroom. You can see if I move my mug, you can see the defendant, you can see the participants, you can see the court. If they had a witness, you would have to shift it a little bit to see the witness, because this down here at the bottom is the corner, down there at the bottom is the corner of the jury box. So you would want to make sure you avoided this corner of the jury box, but put a camera literally right over here under where the glasses are. That's it. Put it there. Put a camera there. You can see. It's fine.
Certainly still individual pictures of Mr. Kohberger, but that will continue to happen regardless, Your Honor.
Well, sure. I mean, in some ways, it kind of misses the point, because it's the sensationalist sort of spectacle that is concerning in
Your Honor, the internet's going to do that whether there's cameras there or not. In fact, I think there's an argument for it being worse if there's no camera to check the narrative.
one of your, the declaration from TV or
Court TV.
Court TV. I looked through, all the cases that they filmed, and some of those you could question whether that was a very dignified way to have a trial. And the classic is O.J. Simpson. So they're saying, oh, this is great. This is great work we did, you know, filming this. But if anybody watched any part of that case, it was a circus.
That case was a circus.
So that is one of the concerns in this particular case.
But the cameras in the courtroom weren't all of it.
A lot of interest, and we have a lot of people that you can't control, that your clients can't control, and they are putting out stuff that is harmful.
What stuff is harmful? Yes, this is the court's concern. Once you stream it into the internet, anyone could grab it and do whatever. And are people going to be irresponsible with that? Yes, they will be. That's going to happen. But what is getting put out that's harmful, and how is that prejudicing a jury or a potential jury pool? What is being put out that's harmful? Somebody joking to 6 comments about Kohberger's fly? Is that really? I have questions about what is harmful and how not having cameras in the courtroom is going to make that better.
It's harmful for the case, for this case, for the process to have a dignified trial. That's my worry, and that's my job. So when I have been talking to the media, just kind of, can you back off a little bit? Because I've been very accommodating, and I just start feeling like, can I really trust them to do the right thing? And it's—
Sir, are you asking if you can trust the internet to do the right thing? No. And if that's the concern, if the concern is that the internet cannot behave itself or whatever, then this judge is going to keep cameras out of the courtroom. You cannot control. You can control what happens in the courtroom. You cannot control what people do outside of the courtroom. You cannot control it whether there's cameras there. You cannot control it if there are not cameras there. You cannot control it. And I argue that you will make it worse because people will show up in person to this community and descend upon it in a way that they might not if they can just have it on camera. And if you don't show the audience, I think you'd get less people showing up in the audience, because you're not going to get people showing up in the audience to want to be seen on TV because court TV is filming into the audience. So if you don't show the audience and you just show the participants in the trial, you might even lessen those that show up in person, right? This judge is not loving cameras in the courtroom because he's like, I can't control what y'all are going to do. No, you can't. You can't control it. Court TV can control what their anchors are going to do. But once Court TV has the pool camera, they can't control who streams it or who clips it down and puts it on TikTok. There is no control. That is the internet. That is the freedom of information that is just, once it is out, it is out.
Not necessarily the camera people, okay? It's where that film goes.
To the internet.
And how it is manipulated. And how—
Has this film, Your Honor, Judge, has anything been manipulated? What do we mean, Your Honor? What do we mean by manipulated? Clipped and commented about and manipulated are two different things. Oh, Judge.
people are, commentators, how they
What commentators?
talk about it, okay? How they—
You can't control how people talk about a case. You can't control. He wants to say randos on the internet. You can feel it. You can feel this judge leaning towards, like, you can't control randos on the internet. No, you can't. You can't control people's opinions. You can't control how people talk about this case. You can't do that either way. And people will show up and sit in court and still go out and talk about the case. Either way, they will either come in person or they won't. Oh, Judge. I think Judge is having a soliloquy about the internet in general. I should have let him go on, but I have concerns.
explaining. And a lot of times it is—
You can't control how they explain it. I'm just going to back up and let him rant about the internet. This is going to make it worse.
Just kind of, can you back off a little bit? Because I've been very accommodating. And I just start feeling like, can I really trust them to do the right thing? And it's not necessarily the camera people, okay? It's where that film goes and how it is manipulated and how people are, commentators, how they talk about it,
I think he wanted to say internet people.
okay? How they explain it. And a lot of times it is not very accurate. And I don't.
The media has gotten so much wrong in this case. If you want people not to get this case, Your Honor, if you want people not to get this case wrong, let them just watch what's happening. And then they can be like, oh, I didn't see that witness say that. Can you give me the timestamp? When did they say that? Did I miss it? Oh my God, oh my God, oh my God. No, you can't control how people talk about the case. Or you. Or the participants. You can control how it's filmed or not. People are going to talk either way.
I don't watch all this stuff, but I've watched
Obviously
enough to see that how disinformation, misinformation is pumped out there, along with the images and with the films. So
the media does that. The media does that. That's not just social media. Legacy media gets stuff wrong. They rush to report things and they get things wrong. That happens. What disinformation and what misinformation? I know, I've overruled myself.
So how do we deal with that? It's not the same media now than it was 10 years ago.
Yeah, they're not the only ones that have a microphone anymore, Your Honor.
With social media, for example. I can't control that. You can't control that. I understand that. I mean, it's going to happen anyway.
Correct.
All I wish is that everybody had a little more respect.
Same.
For what we're doing here. Because
Agreed.
It's not entertainment.
I would love the internet to be respectful, Your Honor. Guess what? The Law Nerds are respectful. The Law Nerds are a respectful group. We are respectful as fuck. And sometimes we also have fun. But you can't just ask the internet to be respectful. I think it would be great. I think that would be amazing. Let's live in that world. I'm here. Let's live in the world where the internet's respectful. Unfortunately, I'm not sure how we can make that happen, Judge. We are respectful. Because you know what? As humans, Your Honor, we can only control our own reactions and responses to things. I've learned somewhere along the road of these 40 plus years, I cannot control the actions of others. Can't control what they think, can't control what they perceive, cannot control the actions of others, cannot make them actually go the speed limit and not 10 miles under it on a 2-lane road on the way to Knoxville. No control. I have no control. I cannot control others. I can control myself, what I accept, and how I respond. That is it, Judge. We cannot control others. I think that you have more than 40 years going for you. I feel like you're older than I am. Your Honor, you've probably also learned this lesson, but you're also a judge, so you like to try to control what other people do. And sometimes you actually get to control what other people do. We cannot control how people behave.
It's a tragic issue, okay?
It's a tragic
And
issue
that
that
is
the
when-
internet's a dick. Hold on, I gotta go back. It is a tragic issue that the internet has no respect. Yeah. But, okay, hold on. Chat. Was the media super respectful 10 years ago? Just, what was 10 years ago? Where were we 10 years ago? 2013? Was the media that respectful? Was there not tabloid and sensationalistic journalism going on? There were still cameras in courtroom, not as many. The story I'm most familiar with, because I've spent the most time with it in the last few years, is Britney Spears. And looking back at the way the media treated Britney Spears, I actually think it's gotten a little bit better. Oh, Cheryl D, you and I are on the same thought. There, it popped up in the chat. Where'd it go? I was going to just pull it up. Cheryl D's like 20 years ago. Look at how the media treated Britney Spears. Right. I think the tabloid journalism has actually gotten, I don't know, maybe we don't tolerate it as much as a society, right? And so we're calling it out more. But 10 years ago, the media was not the same, but it doesn't mean it was better. Tabloid media existed 10 years ago, Your Honor. Casey Anthony was 2011, right? Yes, Dervis said it was slander on the media, if I recall, Princess Diana. See, look, it's just so different. It's different. But I don't know. I think we get tempted to go, you know, the good old days, things were better. I think we have to really take a look, though, because I don't think it was any different 10 years ago. Less people had a voice. Maybe that. Less people had a voice. There was a bit more control because the corporate media outlets could control what was printed in their publications. It doesn't mean it was good. We were talking about the UK phone hacking, where people's phones were being hacked, and that's how information was being shared. That was more than 10 years ago, where the media was literally wiretapping people. So let's not go this route, Your Honor. In your mind, it might feel nostalgic and like back in the good old days, it was better. Shit was still happening.
Social media, for example. I can't control that. You can't control that. I understand that. I mean, it's going to happen anyway. All I wish is that everybody had a little more respect for what we're doing here.
I didn't put the screen back up. Emily, your screen. Your screen, Emily. Your screen.
And I don't watch all this stuff, but I've watched enough to see that how disinformation, misinformation is pumped out there along with the images and with the films. So how do we deal with that? It's not the same.
I am out of practice. I am.
Now than it was 10 years ago with social media.
I am.
For
I went to the woods.
I can't control that. You can't control that. I understand that. I mean, it's going to happen anyway. All I wish is that everybody had a little more respect.
I agree with this.
For what we're doing.
That'd be great.
Because it's not entertainment. It's a tragic issue. Okay.
This case is a tragedy.
And that is what is disturbing to me personally.
Your Honor, if I may, I understand all of that completely.
Most criminal cases are an absolute tragedy. I think the judge is kind of done. I think the judge is kind of done with media and social media. You guys are coming up with great examples in the chat. I love that you're still having a conversation about it. I think conversations about who controls the narrative are super important. And the judge is trying to have those conversations too. But I think people who are like, we need to know about the DNA in this case. I want to see all the evidence about the DNA in this case. There's been questions, a lot of questions. We need to see it. But the only way we're going to see it is if there's cameras in the courtroom. It's the only way we're going to know what's going on. Truly.
I have been in Mr. Thompson's shoes in a very disturbing, heinous murder case with a lot of the pressures that go with that, and dealing with victims and victims' families, and that is a very challenging position to be in. And being able to, I think, Your Honor, having worked in the criminal justice system far longer than I've been in the position I'm in now, I think that in this media day and age, having cameras in the courtroom so that people can see what the proceedings are all about And so there's at least a source out there that says, this is what happened. And if there is not that, that makes it much easier for the people who are going to disseminate disinformation, for the talking heads who aren't going to be respectful of the process to do that. Because then there's none of the actual footage from the trial that responsible media outlets and responsible consumers of information and responsible online people will be able to get access to. I think, Your Honor, the answer is not less sunshine, it's more. I don't think we can afford to abandon to whoever the guy on X or Twitter was that cut out a portion of one photograph of Mr. Kohberger, and then was glad that he got some call out by Mr. Logsdon in his motion.
Oh yes. Oh yes. If you put social media users in your motion, they're going to be thrilled. That is not a deterrent. Do they think it's a deterrent? Because whoever got called out on Twitter in the motion is going to be like, ha ha! See? Okay. That's what's
I
going
don't
to
think
happen.
we can afford to abandon how this case is portrayed visually to those individuals, Your Honor. And instead, frankly, of having pictures in the court, then you just get all the pictures of people going, in and out of the courthouse. But you're going to have the same content, Your Honor. The way to battle misinformation is to provide the accurate information. And the accurate information is what happens inside this courtroom with the cameras positioned in a place that provides the best, most overall perspective of the courtroom. And if there are sensitive witnesses, then the court can give direction and the media will follow that you don't get to film those witnesses. The rule provides you don't get to film the jurors. There are all sorts of sensitivities built into ICAR 45, and the media would ask the court to use those tools
It's easy
rather
to
than
do.
saying, no, are not going to allow cameras in the courtroom. We're not going to allow video in the courtroom, because then you just don't get that accurate picture that they can portray out there. And Your Honor, I do think, with all due respect to the comments that Mr. Logsdon made in his reply brief, the members of the media who are in this coalition, who I think are covering this trial, who I think includes the news editor from the Daily Argonaut from the student newspaper at the university, they are here because they think it's an important public service to cover the proceedings in a criminal matter of such importance to the university, to this community, and I think, Your Honor, really to the state of Idaho. And as I recall from my comments when we were here in June, I mean, this case has affected.
But also to Brian Kohberger, right? I mean, people deserve to see if he is convicted and sentenced, the death penalty is on the table in this case. The community also has an interest into how that conviction is being prosecuted. The community has a right to see the evidence against him or lack thereof. The right to see how the DNA was derived, or if the FBI didn't turn over whatever they did to derive it. The public has the right to know if this prosecution is being done fairly. The community has the right to know if these victims are getting justice or not. They have the right to see it. I like it. I like it when Olsen starts she gets into her mode. And when she gets into mode, we're like, yes, thank you. She's in mode.
People all over the state. There are young people who were students at the university that I know who were affected by what happened. And having some ability to understand the proceedings and to get the closure will be important to them, Your Honor. And I think this court, this court accomplishes much more by allowing the cameras to stay in the courtroom and giving them firm guidance and working with them than it does to send them outside. If you want to see spectacle,
Done.
I mean, see the 40 cameras set up outside of the courtroom, and every time someone walks out, they sort of get ganged up on. I mean, that, I think, Your Honor, is spectacle. With respect to the O.J. Simpson trial, which is, I think, one of the first sort of highly covered ones, I think the point of that one was too, like, look, you can have camera coverage of these cases, and the person, it's still possible for them to get acquittal. It's not prejudicial in terms of guilt or innocence to have cameras in the courtroom. But I think everybody learned a lot from.
Stephanie M. This is Attorney Olsen, the attorney that represents the Media Coalition. Interesting enough, she also represents the university professor who has been allegedly defamed in the TikTok defamation case. So she is in this case 2 ways. Interestingly.
That trial. It certainly didn't reflect well on poor Judge Ito. It didn't really reflect very well on the prosecutors. There are things that may have been playing to the camera because of that. But I think we all learned a lot from that, Your Honor. And hopefully, changes can be made about where the cameras can be positioned. And then part of it's the responsibility of the participants
You're done now.
in the courtroom, not to adjust their behavior for the cameras. I don't see, Bill Thompson, the late Cobb County prosecutor, years and years and years adjusting his approach, or Mr. Nye, or the others who are working on this, because there are cameras in the courtroom. I know Ms. Massoff, I don't know these lawyers as well. I know Ms. Massoff is not going to adjust her performance in the courtroom, and she's going to do everything she can for that client, and I trust these lawyers will too, regardless of whether there are cameras in the courtroom. And I think, Your Honor, the public and this community will be best served by having those cameras in the courtroom and making sure that the guidelines that the court wants to put in place are there, and that there's this firm understanding by members of the media that they will follow that. And I just think it's just not true that that the people who we represent and the people who are in this courtroom today are here to make a spectacle of this proceeding.
I agree.
Thank you, Your Honor.
Thank you, Ms. Olson.
I think the most persuasive argument is there is room for constraint, and there is room to address the concerns of the defense and the prosecution without removing cameras. And I think she should have asked the court, can we look at the least restrictive means necessary pre-trial? And then if we need to readdress it, we'll readdress it. But the least restrictive means would be putting out a court order, not a guidance, not an advisement, not a wouldn't it be nice if you don't just focus on Kohberger. Put out a court order, camera decorum in the courtroom, and list an order of what's allowed and what's not allowed. Just make a court order. That is the least restrictive means. And if the media can't adhere to it, then you go next.
So I just I hope I sent out a message to the media and everybody else that please have patience, be respectful, and be decent. That's what I want. So thank you.
Thank you.
Your Honor, we would all like the internet to be patient and decent. However, not all humans are patient and decent. I'm definitely not patient.
Okay, any response to any of that, Mr. Logsdon?
I'm sure Mr. Logsdon will have some
You don't have to.
response.
I guess not really sure where to go with that one, but obviously nobody's talking about throwing the media out of the courtroom or.
He said, obviously no one's talking about throwing the media out of the courtroom. You want to throw the cameras out of the courtroom, sir.
Making the case so dark, I wouldn't want that. After all, I think the public definitely plays a very big role in making sure that we all do our jobs right. We're just talking about the images that are coming out of this. Sounds like the court, here's where we're coming from. I don't think I have a whole lot more to add to that. Thanks, Judge.
Thank you. Mr. Redley?
He's arguing we're not trying to throw the media out of the courtroom entirely, just the cameras. They can still come into court. They can sit here with their little notebooks and then they can go back and report on it, but cameras, just cameras.
Okay. Well, thank you all. I think it's a very interesting, really kind of powerful issue that
I agree.
is
We have only one more day of Mercury retrograde, and I'm really thankful for it. We're going to finish up this hearing. I don't even know how I got kicked out of my own stream. One more day. One more day. One more day. All right, y'all. Let's pull this back up. I am going to scooch just a few seconds back because I know that we missed some of it when I got yeeted. Good Lord. Let's try this again. Sigh. Sigh.
Sounds like the court, here's where we're coming from. I don't think I have a whole lot more to add to that. Thanks, Judge.
Thank you. Mr. Redley?
Nothing further, Your Honor.
Okay. Well, thank you all. I think it's a very interesting, really kind of powerful issue that is a benefit and also
It is a powerful question. It is an important question. And I hope that he is very much feeling the weight of how important it is for access to this courtroom and how much worse it will get if there's no access.
potentially harm. And that there's a lot of balancing that will go into this consideration. Of course, I am especially sensitive to the parties of the case. I saw Mr. Thompson kind of smile a little bit about, there were in a lot of these cases where they were sensationalized and heavily filmed and talked about. The defendants were acquitted. And so therefore that proves that they got a fair trial. Well, we want trials to be balanced for both sides. And I don't know if I was reading your mind a little bit about that, Mr. Thompson, but it can tilt. It can tilt a case one way or the other. If the media is, trying the case in the media. And we don't want that because that's not based on evidence. That's not.
Your Honor, this is a high profile case. And so I know you would like there to not be a court of public opinion. There is going to be a court of public opinion. That court of public opinion will be better informed, or at least the ones who want to be, will be better informed for letting us just see what happens in court. But the court of public opinion is going to happen no matter what you do.
Not based on the rules of the court, and it can get out of control. And I think some of those cases that were cited in the declaration, court TV, personnel, are kind of seeing it one way, and they have a certain job to do.
It's their motion. It's advocacy. Of course they're seeing it one way, in the way that benefits the media. It's their motion. He's not done thinking out loud.
I understand that, but some of those cases, in my opinion, kind of spun out of control. And that based on the media and how heavily it was covered.
This concerns me. This concerns me. He feels in his feels that some of the cases cited in the motion that we read, quote, spun out of control because of the way the media covered them. The exterior of a case and what happens in the case are so different. So does he think that cases that appeared to be a media circus on the outside were impacted inside the courtroom? And how does he know that? It feels like he is very much leaning against cameras in the courtroom, or at least leaning towards restrained cameras in the courtroom. I think there are at least restrictive means, but it doesn't seem that he seems very concerned with not what's going on in the courtroom, but very concerned with what's going on outside of the courtroom. very concerned with what's going on outside the courtroom.
So that's my worry. I'm going to figure it out and try to do the right thing for both the public and the parties and
Well, the parties don't want
the rule
cameras.
of law. So with that, we're adjourned. Thank you all.
The parties don't want cameras. Court is adjourned. The parties don't want cameras here. And that is a part of this, is that the prosecution and the defense have both said we're cool with no cameras. So it's going to be real interesting to see what he rules. It's going to be a written ruling. We're not going to get to see him talk it through. And that's
In my
the end of that
case,
hearing. We're going to get to Q&A. I know that there is a hearing ongoing
we're on the same page.
I've melted a lot of YouTube. Shush. I know that there is an ongoing hearing today in the Murdaugh case. We are going to cover that another day. I think it's still ongoing. I think the Murdaugh hearing was still going the last time I checked. It might have wrapped up by now. But there's lots going on in Murdaugh. I have lots of family things where I have to drive and pick humans up and get them around today. So I do not have time for a supersized stream. We're going to get to some questions. I feel like the judge is more concerned truly about what is going on outside of court than inside of court with the media. And that's not something he'll be able to control either way. And it worries me that he's going to try to control the internet by not allowing cameras in, because that's not going to work. The internet is still going to internet. And I think the internet, the lack of cameras, I think will make it worse. It will leave people unsure. And I think it will leave people to question the verdict. And I don't know if that will feel like justice to the families of the victims if it really ends up with a verdict that everyone questions. I think that's really, really frustrating. Okay. With all of it, I've got questions, you've got questions, we've got questions. Let's just get to questions. We're here now. Let's get to questions. We will cover Murdaugh another day. All right. I know y'all want to cover it. I want to cover it too. We will cover Murdaugh another day. And when we cover Murdaugh another day, we will be able to do it sped up a little and skip all the gaps and kind of condense it in time. So do not worry. It will get covered. It's just not getting covered today. All right. Okay, everybody. I don't know where my pickle is. Vincent Van Gogh. Judge Abby and I were joking about Vincent Van Gogh. Vincent Van Gogh says, it's time to get to questions. So let's go. But I definitely think this judge is this judge feels inclined against the media at this point. I hope that he takes the constrained approach and gives a media decorum order and then narrows it down from there. That's my hope. I am nervous about that. Jan said Murdaugh was a short hearing, but there was also Corey Fleming stuff. So we would do the whole day because Corey Fleming is Murdaugh adjacent enough that it's all intermeshed. So we would do it all together. Naughty says, I beat my ADHD today. I caught a live. Congratulations. It's a fight for me every day, which is an adventure and a delight. Sometimes more than others. Thank you for the Bring the Emily Law Nerds. I appreciate you. Members, it's always so good to see all of you. And because the channel has been growing for so long, we've got some members who are like, I have been 31 months is so incredible. Thank you. I saw Octo put one in too. Megan, happy birthday. 34 months. These are absolutely incredible. Call me out. Feel better. We'll see you soon. Good luck with sinus surgery. It's going to be great. So it's great to see all these come in. Question, Dep v. Heard sidebars. Anthony, we're going to get back to them. I promise. There are some time sensitive things we need to cover. We're going to do it. Glass Onion said, I live in Westchester. It was very stressful. The only reason I knew anything about what was going on in Pennsylvania is because my dad is from that area originally. And so I was hearing about what was going on because he went to school out there and he grew up out there. So yes, very close. Octo is the OG. 34 months. Thank you, Octo. It's good to see you. I'm so sorry, Jennifer, for the loss of your amazing paw nerd. It's awful. Emma said, in honor of helping get through a year of grad school and finally getting my first marketing position since I graduated in 2020, should get my MBA in 2024. Congratulations. Emma, let everyone just cheer for you. That's fantastic. Rosebud said, my son made it into percussion in 5th grade band. Congratulations. Percussion is so much fun. Look, I know everybody has their own love, but because I did color guard, it's not because I did color guard. I did percussion before I did color guard. I switched to color guard for a large variety of reasons, but I switched to color guard from percussion, but my heart has percussion has my heart. For sure. It also was a little bit easier. Percussion made sense to my brain, more so than other instruments. I love it. I love it. So yes, before I got to guard percussion. If you go to Idaho, I'm driving. If we go to Idaho for trial, we'll do a meetup at some point. There are enough others covering the 8-passenger case. Don't put yourself through that. I will do it from the law nerd level. I really hope that the way I cover it makes it accessible to those of you that want to engage in that case, but don't want to deep dive into every single detail of that case. So some of y'all have seen it. Ellen, you see me. Uh-huh. 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 I love you guys sharing all of your band love here. Mary, thank you so much. Thank you. We are here for you. I'm glad this space is here. It's a hard next chapter. Absolutely a hard next chapter, but we are here for you. So that is what it is. The law nerds are here. My godson is flying for the first time. He's in Charlotte Airport. He keeps saying Charleston on your behalf. I warned him to be cautious. Yes, but at least they're drivable. If you end up in the wrong one, and they're both lovely, it's fine. Sweet Baby Ray said, how do they plan to prove that the photos are from band zoom/focus in court, not pulled from a wider shot? They can't. They can't. They can't. So, and they don't have to. The court gets to decide. This is all up for the discretion of the court. And the court's like, let's have a chat about it. And that's why we're here, because the court is open to having a chat about it. Is there a way for you to file a request in courtroom with all of your thoughts? I am not filing an amicus in it. I am not getting involved. The media coalition doesn't need to hear from me. They've got, the executives at Court TV handling it, so they will be fine. They do not need my input, but I think they need to remember how well the court orders worked in the Paltrow case. So that is what we will see going on. Gingy Probs, I 100% believe in innocence before proven guilty. Media coverage will cause bias, but how does streaming cause more bias, let alone harmful ever? Couldn't the court just give specific instructions? I think they should. I think they should. I think that's exactly what the court should do. Give an order. Just give an order. That's all. Tubby Tilly, you make an excellent point saying, I live in Spokane and I'm disabled. I can't go to court and want to know what is going on. And that is solved by cameras in the courtroom. Not a lot of people argue disability access, but it is a huge part of access to courts, and cameras make it accessible. And you are a member of the community. You should be able to know what's happening. Would judge call Judge A or Judge in Wisconsin how they handle cameras? Probably not. Or can they only consider what's presented by each party? Judges can have conversations with other judges for advisement on all kinds of things. Would this judge look outside their jurisdiction? I don't know. These are the kinds of things to talk about over a drink at a judicial conference. This morning in KC, I had on my I Have Questions shirt, 2 guys putting a French drain in at my apartment complex yelled EDB. I don't know what the drain is, but I think that's amazing, and I love it, Casey Cat. That's so good. I love it. Tell them thank you. Did you skip the defense? Stephanie, you saved the day, and I appreciate you. Thank you. Very happy to have caught a live again. Yes, I feel like I haven't been live in a minute. Like, missing a live makes me feel all unbalanced. Big hugs to our mods. Depfy NGN had no cameras and published transcripts. Reading transcripts wildly changes the fairness of the ruling, but little did, and media ran with it. I have not read all the transcripts there either. Can we get an analysis of how much OJ was in frame? That's a very fair point. We need to see a breakdown of how much he was actually shown in the trial. In the business trial, they focused the camera on the seal for testimony of victim's family. Maybe that could work. Yep. Audio only, not video. And I think it worked well in the business trial. There are ways to do this. And there are good ways to do it. For Axel said, your lives help me calm my anxiety. Thank you. Well, you're welcome. I'm sure you have other ways too, but this community makes me feel like I'm having a normal week too, getting to do this. NJ Kathy said, after the coverage of the media on Deppy heard, all trials should be broadcast unless they involve juveniles. And what's interesting is the juveniles don't have an open court. So juvenile court, if the perpetrator is a juvenile, the court's not open. So it's not open at all. So that's never going to be an issue. And then if you have testimony of minors, it's real easy to turn the cameras off. It's just like it's easy to seal the autopsy photos so they aren't out and they're not shown on TV. There are rules that are made and followed. And when you use like Court TV or Long Crime as the pool cameras, they care very much about getting it right because it is their livelihood to get it right. When they get it wrong, that is the basis of their entire network. I mean, I also read documents. The basis of their entire network is live court coverage. If they get it wrong, it is the entire network. They have a lot of incentive to do it right. So, I agree. I think courts should be much more open. The Silverleaf said, if cops have body cams, so should courts. We don't trust any of you anymore. Put a camera above the jury so we never see them and we see what they see. The Silverleaf, it's a great idea. And also the reason police have body cam is to, in theory, protect everyone involved. If the police say it went down one way and the body cam shows that it's different, then you know. If the perpetrator says it goes down different, then you know. Right? The video shows the video. If it's not edited, the video shows the video. And that's what happens in trial. It shows the trial. Hi, trial. Things happen. That's it. Transparency everywhere. So BC said, we've seen so many cases where the media does not paint unbiased picture. I don't know if a lot of media knows how to. Thank goodness there were cameras. The victims should have a say as well. No one has mentioned them. The victims in this case, sadly, do not have a say. The victims are deceased. The victims' families probably have thoughts on this, but the prosecution wants to protect the witnesses. And I understand why. I think we'll see what the victim's family has to say if we have not seen it already in the media. I've seen a lot of comments saying the victim's family, some of them really wants cameras in the courtroom. And if I was the victim's family, I think I would want that too, because you want the public to understand the result either way. Let's see. Do you think if cameras are banned and chaos ensues, he will change his mind? Always possible. It's sometimes hard for judges. Feels like the judge is blaming the public. Feels like the judge to me is blaming the internet, but I think he's nervous. And this is a thing. This judge, I don't know if he's ever had cameras in a courtroom before or a high profile case quite like this. This is a very large case for this jurisdiction. Other judges in the jurisdiction have gotten cameras out. So it seems like the thought for the jurisdiction is cameras out is the way to go. And those are the judges that this judge has the most contact with, right? Other judges in this jurisdiction. So he's skeptical that this will not become undignified. And he doesn't want that to happen. But there are not a lot in the media, and there are some that do it exceptionally well, who will just tell you what happens. I am in court. This happened, then this happened, then this happened, then this happened. And it's great. But you have to pick and choose and find that, because once the media stories get running, those all have a lean. They all have a story. Generally at this point, media stories have a premise, a headline. They've got something that they're trying to say. They're not just straight reporting of today, these 3 things happened. And we heard in my podcast interview that I did with Mandy Matney. If you haven't listened to that podcast, please do if you're interested. But we talk about when she was working in traditional legacy media, how much everything was tracked, how each journalist or reporter got a list of how far down a page somebody read their story, how many people clicked on their headlines, how many people subscribed or paid the paywall fee because of their stories. They were tracking all of that. So now journalism is not, this happened today. Each individual reporter, it seems, go listen to the interview yourself, it seems each individual reporter is now fighting for clicks and views with everybody else. Fighting for clicks and views with everything on Twitter, fighting for clicks and views with everything on YouTube, fighting for clicks and views with everything on TikTok. So the media is also fighting for clicks and views, where it used to be that the media conglomerate sold advertisements and they were a local media and that was the paper that was getting handed out and they weren't fighting for attention. So they could just report. Now they're fighting for attention. The next person on the right said she also said she wanted to give her opinion and not be neutral. She did say that she wanted to stop trying to be as neutral as possible. She did. And I'm like, I need some of y'all to just tell me what happened. A, B, C, D. Please. Please. Level 40 here. It's hard getting to the next level of Pokemon. Yeah, I'm 42 trying to get to 43 and I have 5 million out of 9 million XP. I got a long way to go. And I've been trying to grind during this event for Pokemon. And I thought I was going to get to do that on vacation. And then there was no cell phone and no Wi-Fi. And I could not, I was ready to just kind of have a chill Pokemon grind. And it did not happen. So, this seems like a conversation that's going on. So I think this is great. Almost every stream, someone comments how they're studying law because of channels like these. And I think that's absolutely amazing. I think we need more and varied voices and perspectives in law all the time. I literally, sorry, my brain just stopped. I literally only read the Jack Smith indictment, all 44 pages of it, because I watch LawTube so much. If it wasn't for quote unquote new media, I wouldn't have cared nor known what any of it meant. Emily, I'm so glad. Increasing literacy of the law is literally the whole central point of what I do. Helping people understand and decide for themselves. I want you to be able to understand this information. And if that means, look, if that means that you're like, hey, I want to go see like the 8 passengers probable cause affidavit and I want to read it, I'm not worried that you're going to read it before I cover it. If you want to hear what I have to say, you'll be here to hear what I have to say. If you just want to take what we've talked about and understand it and read it yourself, great. I'm not bothered. I'm not worried, right? I'm not worried that you'll figure it out for yourself. I want you to be able to do that. And I want you to be able to engage in all the ways you want to engage. A lot of times you guys will listen to these stories or watch court proceedings before I cover them and still come back so we can all do it together. Because it's not just me, it's our community having a conversation. And cameras in the courtroom is a critical conversation. And it's a critical conversation that we still need to have. And then we'll talk about federal court later. I was 4'11" and played the bass drum. I looked like a drum with legs. Elena, probably, and that's amazing. I liked snare and quads. Snare just went, there's just such a clean tick to a snare drum that I just love. My kid's personal Uber driver, I'm trying to grab this. I saw it on my other screen. My son comes home with new cases in his forensic science class, and I get so excited when it's a case I know. Amanda Knox this week. That sounds really fun to get to go through while your kid is going through education, that you are getting to go through it with them and just be like, I'm excited. I love that. I love that. Denise, thank you for this. You're so right. Knowledge is power. Go flutes and saxophones. I really hope that channels like mine and others not just encourage other lawyers to share, but increase legal literacy. Legal literacy is hidden behind very expensive education, and it shouldn't be, because it governs everything that we all do. We should be able to understand, I think. As someone already said, I'm scared about the precedent this will set. It's Idaho, so it's only for Idaho, but those precedents in Idaho are already being set in Valadabel. It's already happening. Already happening. By watching your channel, we could tailor our revocable trust to what is best for our daughter. Thank you. And try Tom's rule. You guys are the best. Y'all are just the best. I love all the nerdy band language. I love that we can have a conversation between cameras in the courtroom and access to media and access to law, and what reporting has become, and legacy media versus new media and all the rest of it, and Pokemon Go and band. Thank you. You make my day. Is it wrong for the judge to pay so close attention to social media? He says he doesn't pay attention, but every hearing he responds to things said on the internet. I think he's paying attention because he's concerned and he's looking for validation for his concerns. Truly. Or he really wants to see what people are saying about him, which is kind of human, especially if you're new to the internet in this way. I'm going to be the weird one and say oboe was my fave for band. Learn flute first, but oboe is my love. Not weird. Oboe's great. I don't know how to play it, but it's lovely. The real deal. Could legislation permanently answer this question, or does it have to be decided by the judicial branch? It would have to be carefully constructed because these are constitutional rights. It's much more something that gets kind of decided by case law on how do we interpret access to court? So would it be legislative overstepping? I would have to think about, but I think these would be more like judicial council guidelines. But no, you could have the rules of court and stuff determine these things. So kind of, yes, it could be, but it couldn't be cameras must be allowed. There has to be room for the judicial discretion in it. But yes, it could be the rule of court is cameras are allowed unless A, B, C, and D, and the court is allowed to restrain them in these ways. So there are some guidelines. I think that might help a lot of judges. Did you see the guy who rides around on his bike with 64 phones? I have, and it is a fantastic meme, but I've seen video of that. Your Honor, since knowledge is power, LawTube is Schoolhouse Rock of the internet. Therefore, you must allow cameras with appropriate protections. And none of us complain about the appropriate protections. I don't think any of us gave a shit about what the Paltrow judge decided to do. All of us were like, we want to see the case. And James. And we're going to learn that everybody is sick and sniffling into the microphone. And we're going to learn a lot about skiing and all the rest of it. But we all learned. And we all saw that case. And I don't think any of us were like, what we need is more up close of Gwyneth's face. We just watched what we watched. All right, law nerds. I've got to go pick up kiddos from things. I appreciate all of you. I've got to eat and pick up kids. I appreciate you for being here. Thank you for being patient with my wild schedule. We are getting close to new things for you. So if you are not signed up to Law Nerd Alert, sign up to Law Nerd Alert. I will be live next week. New podcast for you. We will cover all of the things. I am going to put up questions about what we haven't circled back to see what you guys are interested in. You guys are definitely interested in 8 passengers, but nothing new is happening there. So I'm not going to do that. We are going to do Murdaugh. We have time for sidebars. We're going to talk a little bit about Gerardi and get back into the TikTok defamation case and others. There's a lot that we've tried to keep on top of, but there's quite a bit more to keep on top of. So lawnerdalert.com is where you want to be, and I will see you later. All right. Yes, we need to scoop back into Corey Richins as well. We have some live court to cover, even though it's a day or two delayed. So I will see you guys soon. Thank you. Let's go. Law nerds. May your Wi-Fi be strong. May your Pokemon be plentiful. And I will talk to you in the next one. You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at The Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.